You're right.
Therefore, the liability of both RBI and the government as a guarantor got wiped out together, not separately.
Yeah, that's the scheme.
No, you started off with saying that.
No. Let me just tell your lordships in the plainest terms.
My learned brother.
Yeah.
On the basis of contract, I said that once the promisers.
It is
promisers.
So let me answer it. Let me answer it directly in terms of contract. Contract law 1 is subject to statutory law in certain situations. 1, 2. These are separate liabilities and guarantees. One government, the other as far as the RBI is concerned. That's the second point. Parliament could very well choose to extinguish both together. But that does not mean that they in an appropriate or other case may choose to do it differently or distinctly. Please don't rob Parliament of that power. Please. So the answer to the question is
that doesn't fall for consideration as to whether it can be done separately or not.
That in an appropriate case, that doesn't trouble us.
You can't decide on the basis of hypothetical situation.
You should ought not. I said that your lordship certainly ought not. That they have done it here. What I am suggesting is that they have done it here and they've extinguished.
I'm sorry, I'm repeating again and again.
Yeah.
Even if we accept your argument for a sake,
yeah,
the guarantee and even suppose even the promise
yes
exists till 30th of December.
Yes.
And once an ordinance comes into effect.
Yes.
What is the then?
What is the?
I'm not saying, but see, there are two. Sorry.
Please develop the further argument.
So I'll state the point straight away, Manoj. I've mentioned that in the answer. I am not for a moment saying let me answer the question. The answer is twofold, and then but please allow me to complete the argument. The answer is 1. This came in on the 30th of December with a hard stop on the 31st of December with a grace period. So I'm going to request the court to interpret the grace period in a manner which is just and reasonable. Because that's in section 4. My submission is going to be, having regard to the fact that the liability was extinguished, the assurance of the Prime Minister, it would be completely unreasonable, or to borrow the expression, manifestly arbitrary and unjust, to have just 24 hours to change. Because the entire regime until then, as understood with the grace period, is that this is going to extend. This is one part of the argument. The second part of the argument, and I'm going to pick up the Attorney General's note right away. I am going to respectfully submit there ought to be clarity as laid down by this court. And that's the second part of the argument, because I have to deal with the arguments which were made in writing. So now I have mentioned to the court now let me just sum up on this part and I'll come to section 4. What section 3 does is, therefore, it only does one thing or two things. Extinguishes central government guarantee, extinguishes RBI liability, and therefore builds on what has already happened. So what does it not do? And that's very important. It does not validate anything which has happened earlier. 1, there is no question of merger. Number 2, and that's my respectful submission. Now please pick up, because before I go to section 4, please pick up the Attorney General's submission. Only 2 paragraphs. And those are para 2.5.3 and 2.5.4. This is what I am addressing now in all this submission. Please go to 2.5.3. This is the additional submissions of the Attorney General. If it's the same copy that I have, it should be on page 11. Only 2 paras I'm going to read. It's a para beginning nevertheless. 2.5.3. It's titled Additional Submissions.
Page 11.
Yes, and it's handed in on the 5th of December.
This was on the main argument were advanced on this basis.
Yeah. Your Lordships have it? Correct. So now let's read it. Nevertheless, the submissions advanced by the petitioners carry no weight, insofar as they fail to appreciate that even in the present case, the government exercise of powers under 26(2) has been incorporated by reference. Please mark that. First legal concept, incorporated by reference into the specified Banknote Cessation of Liabilities Act 2017, and therefore the same was effectively been validated by an act of parliament as well. So this is the second legal concept in this one sentence 2.5.3. Incorporated by reference, validated into an act of parliament. 2.5.4. The notification of 8th November 2016 has been affirmatively referred to in section 3. By such affirmation, Parliament can be said to have taken into account the notification and its implementation scheme. As a result, since the notification has, now this is the third concept, merged in the parliamentary law, it has ceased to exist independent of legal instrument. It has ceased to exist as an independent legal instrument. It must be taken that regardless of any issue relating to the exercise of power under section 26(2), the decision to withdraw existing series of certain denominations from legal tender must be treated as a parliamentary plenary declaration. So there are 5 concepts, maybe there are more. Incorporation by reference, validation, merger, cease to exist, the notification itself has ceased to exist as a legal instrument, and parliamentary plenary declaration. Now I'm going to respectfully submit very quickly that each one of these is incorrect in my respectful submission. First of all, I would respectfully submit that this is muddling up all sorts of legal concepts which can't be muddled up in these 2 sentences. So let me specify. First concept, incorporation by reference. Incorporation by reference is a concept, is a legal concept which this court regularly applies, where a statute doesn't want to repeat all the statutory provisions again and again because they are already contained in another statute, and therefore it makes a reference to that particular statute. And then there's a whole body of case law as to whether amendments to that other statute get incorporated here or not. That is the concept of incorporation by reference. Here there is no incorporation by reference. There is certainly a reference to the other notification which was in the executive realm. This ordinance is dealing with legislative power, completely separate and distinct. Second concept, validation. Validation arises when something is declared ultra vires. It may be ultra vires for a variety of reasons. There's no concept, no court had said that this is ultra vires. No one at that point of time requiring validation. In any case, 26(2) is an executive power, doesn't confer any authority on parliament. There's no question of validation. So that's my second answer. Third concept is merger, merged into parliamentary law. My respectful submission is this is 2 distinct things. One was an administrative action under 26(2). Another was an extinguishment of liability under 26(1) and 34. There's no question of merger. The fourth point is ceased in law, it has ceased to exist. I think this is, well, I don't think this is even stateable, frankly, except that the Attorney General has stated it. It has its life. It had complete impact across the country, and it had full force of law, subject to, of course, what your lordships now hold. It had the full force of law, and it operated immediately on being issued on the 8th of November 2016 until the 31st of December when there was a period, but it ceased to have any legal tender basis. So this to say that it merged into a statute is again, in my respectful submission, ceased to be an independent, it continues as a legal independent instrument. The bullet has been fired. It has, in the form of the notification, it has carried its course and it has done what it has done. It doesn't cease to it. It doesn't have any impact or effect later on because it was self-contained at a certain level. But legal tender immediately stopped. And finally, it must be treated as a plenary parliamentary declaration. I don't think any plenary parliamentary declaration is made or even attempted to be made by this one. So that's my respectful submission. Now we come to section 4. Now, before we come to section 4 of the ordinance,
How can it be given that by a plenary parliamentary declaration?
Yeah, there is none.
No, a specific statement is made that from 31st of December so and so,
Yeah,
all these specific bank notes shall cease to exist.
yeah,
And the guarantee and the promise
absolutely right.
shall cease to exist.
So just see that
It is regarding
it's
notification.
2 different things, my lords.
It is
Where's the question of merger cease to exist? Please, what the ordinance does is it extinguishes, sorry.
What has been done
Yeah,
under the notification of November,
right.
what was provided was that
Legal tender,
it shall cease to effect from legal tender.
correct.
And it granted a window till
Right.
30th of December to exchange the notes.
What does that mean? The guarantee was still there.
Guarantee was there.
Yes, why was it there? Because that's why you could exchange notes.
And therefore, because
So-
you see the fourth,
No, but may I just, sorry, with your permission.
you see the fourth whereas.
Yes.
And whereas it is necessary to have clarity and finality.
Finality, yes.
So the parliament might have thought that there might be some ingenious arguments, and therefore to take care of that.
No, this
they
actually,
create a specific ordinance.
yeah. So I'm actually obliged to your lordship's
So,
question because I
again-
think it answers the earlier issue
Yeah,
which I
if
Sorry.
your argument is to be accepted,
Yes.
it will have so much ramifications because under the 1778 Act, there is no such declaration under section 26 and 34. And those 10,000 notes will still have to be honored and by the government.
Sorry. No, so let me just, Manoj, I think part of it is answered, part of it is answered. The fact that the guarantee and the liability continue on and after 8th of November 2016 is now I'm supplying two more reasons. The first reason is it's clear from the fact that they exchanged notes. That's reason one. And the second is,
That the notification itself provided.
yeah, of course, because of a guarantee which was extant and outstanding, and because there was a liability which was extant and outstanding. That's the reason. But there's another reason. The second reason is that you could not have an executive direction which invalidates a statutory obligation under 26, 1 and 34. That's the elementary proposition which we are canvassing. Of course, there may be some subtle argument under contract law, but the legislative argument is, or the administrative law argument is, or the constitutional architecture argument is, that you cannot have executive action nullifying a statute under the very statute under which the executive action is issued.
I've been repeatedly saying that even if you accept your argument,
Yes.
that the November notification.
Correct. So now now I'm only on that. Now I'm only on that.
Under the state notification also the deadline
Yes.
was the same, and under the ordinance also the
All right.
deadline.
So now let's answer that. Now we are focusing on that. Now we are focusing on that. So first, your lordship, of grace period.
Are you trying to say?
Yes, sorry.
Are you trying to say that it was because of the guarantee which continued,
Yes,
that there was provision made for exchange of notes
absolutely.
and the banks
Absolutely.
see, they ultimately, because the banks accepted the notes which ceased to be legal tender and they gave valid notes, the new notes. Otherwise, the banks had no duty to exchange the notes which the central government had said had ceased to be legal tender.
That is absolutely my point. My point is that the guarantee and the liability continue.
The provision for exchange is a continuation of the guarantee.
Absolutely.
The guarantee is extinguished. You may say that.
No,
That is my very submission. Manoj, let's be clear. Manoj.
provision for exchange.
Yes, sorry.
In the notification.
The provision for exchange is a
Yes.
continuation of the primary liability itself, not
Yes.
just the extension of the guarantee.
Government guarantee,
No, the liability, the RBI itself continues.
34.
Therefore, the notification did not extinguish the liability. 8/11/2016.
It could not.
Because they said the window is open for exchange. Unless, if suppose the liability is wiped out on 8/11, they can't re-exchange the notes. Therefore, that is the reason why the liability continued. Legal tender also only ceased to exist.
Correct. The liability, otherwise they would not have.
Not just the
accepted-
guarantee, not just the guarantee,
accepted
but the
bank-
liability.
The
Not
bank,
just the guarantee.
I am in 100% agreement with the observation made that on and after 8th November, according to me, the liability continued, the guarantee also continued, both continued. Eventually, as Justice Gavai has correctly pointed out, extinguished on 31st December 2016, subject to judicial review by this court. But that is the scheme which was followed. So that is why, because I'm obliged for that question, the reason why they were obliged, apart from being in terms of the notification itself, there was an outstanding statutory notification. Your lordships have noticed my point. Being an executive, that sort of the tail can't for the power coupled with duty. Now, for that, let us go to page 44. Because I'll just indicate what has happened here. I'm now responding. I thought it was fairly insensitive, but I mean, we can't use stronger expressions than that to describe the attitude of both the Reserve Bank of India and the Union of India. These are genuine cases. What are you going to do about them? Now, please see 44 first. Go to page 44. Now, this is what they do on 30th December 2016. Now, I am relying on a part of this notification. And I am going to show your lordships 2-3 ways out. If we are right. Please go, stay same compilation 1. Please go directly to 44. Now, just see the first part. In exercise of powers conferred under clause B of subsection 1 of section 2, read with clause 1 of subsection 1 of section 4 of the specified notes, that's ordinance, the central government hereby specifies in respect of citizens of India referred to in clause so and so of the set. So this is issued by the Ministry of Finance. Please note that this is not an RBI notification. It's a Ministry of Finance, Government of India notification. Now see this, I am quite happy with A, who is a resident of India. So they are specifying the grace period, who is a resident of India for the period ending 31st day of March 2017, and B, who is not a resident of India. This is what covers me, a period of 30th day of June 2017 as the grace period for the purpose of the said ordinance. Now, so far, I am in a very happy situation because it's still the 30th of June 2017. I'm in a KYC account. I've got the money, this, that, and the other. There's no problem at all. All right. This is one aspect. Now they have a proviso. So there are 2 ways of reading this proviso. First, let me read it and then make the submission. Provided that the amount in the specified notes rendered does not exceed the amount specified under Regulation 3 or Regulation 8 of Reserve Bank of the FEMA dated 29 December 2015, made under provisions of the Foreign Exchange Management Act and the conditions specified therein are complied with. Correct? This is the proviso. Now, first submission. This proviso can only apply to people who during that period were out of the country. That's one. I am not there. I was sorry, it can only be applied, my mistake. It can only apply to people who carried currency out of the country, and who were away. The proviso, well, let's see, please see, who is resident in India for a period ending 31st day of 27 and who is not resident 30th June 2017. So I am saying let us go by this part of it. It will be enough. It gives me relief. There's no problem because I landed well before 30th of June 2017. In February itself, I tendered my money in one case where, so there is no problem. And insofar as for people who are out of India, correct? So there's no problem. Now, what is the effect of the proviso? The proviso restricts it to someone who carried an amount abroad and brought it back. Now, I was not in that category. My money was lying in India. So, therefore, the proviso has no application. So, this is one way your lordships can grant relief to citizens who had left the money in India and were away from the country during that period. What is the method? The proviso does not apply to people who had left the money in India. That will give a huge amount of relief to people such as myself, people such as who Mr. Rao was representing, etc. Sorry.
What would be the mechanism?
No, it's...
No, to find out that those non-resident Indians had genuinely kept the money when they were traveling out.
So they have to be satisfied. That will be on a case-to-case basis.
The notification are for 2 classes.
Yeah.
Insofar as the persons who are residents in India, there is no such restriction.
There is.
No. If there is subsequently it is clarified.
No, we'll come to that. Your lordship is right. There is that clarification which I'll deal with.
For resident in India,
Yes.
there is no limit.
Yeah.
There is no requirement for declaration.
Correct.
Then the proviso is applicable only those persons who are NRIs.
Right. So how? So if what about an NRI who has left it in India? Well, I mean, that's like, can you imagine what a huge group of people that is?
Well, even NRIs don't have a
NRI,
restriction.
sorry?
Even NRIs don't have a restriction up to 31st of December. The rest
No, we are talking about grace period.
Then Mr. You are that asking them to return at before 31st of December.
is unreasonable, manifestly arbitrary. and
Yes, it is manifest or extraordinarily cold-hearted.
Where,
Maybe the tickets would have costed them more than
Millard,
1.5 lakhs.
Millard, what was he doing for these 2 months when the notification said that he will get this opportunity only till 30th? Can he say that he can
It's an
enforce?
astonishing submission.
Can he say that
It is the most callous submission on behalf of RBI.
merely
to make
using the word
submissions
callous
like
will
this.
not help?
Atmosphere outside is quite pleasant.
And polluted.
So according to him,
Yes.
this has to be linked with right to life. Right to
Millard,
he has a right to live with dignity, and
Yes.
therefore is not expected to come back for this party 1.6 lakhs. When the tickets itself would have costed him more than that.
Milord,
No, it's much more. Actually, it's much more than that. I will explain that to you.
he has come back in February. He could have come back in November. Milord, the question is whether no opportunity was given to him or not.
We have noted your argument yesterday that till 31st of December,
Yes,
everybody had opportunity to do away with everything.
everything.
Now, let me just deal with this argument right away. This is a wrong submission on facts which is made because until the 30th of, so please note this now.
Till 30th.
Until 30th of December, the assurance given by the Reserve Bank of India and the Prime Minister of India, no less, was that you will have an opportunity even past that date. And I'm going to point that out.
Milord,
And
we
it's
have
only on 30th of
This
December they
argument
said
has
that
to
the
be-
hard stop on 31st December. Is that reasonable?
We permit you to address because
Milord, this is a rejoinder. Milord, it is very difficult for me, Milord, to collect all this material and give it to your Lordship today. So I'm, Milord, the ones which are obviously incorrect, Milord, please permit me to point out. The notification said that exchange will be permitted only up to 30th December. So this argument that Reserve Bank said that he will get after 30th December, that the Prime Minister said that he will get after 30th of December, all this is, Milord, irrelevant. The notification, which is the law, said 30th December. He knew that.
When did that notification come?
Milord, 8th of November, this is the first notification.
Oh, you're referring to.
First notification.
No, there was another notification of 30th of December.
No, the
Yes, I'm coming to that.
I'm sorry, Milord,
that is
30th,
what you are reading.
30th December, Milord, is grace period notification.
Grace period.
But Milord, there is a primary notification which gave them the right to exchange whatever they wanted to. And Milord, the answer to your Lordship's question as to why would banks honor after Milord 8th of November is because the notification said they will honor. Milord, the notification said so. They will honor under these circumstances from the beginning.
That is
So it's the
because
law.
Central government has guaranteed the currency.
Milord, it doesn't matter whether they
Liability.
Milord, it doesn't matter whether there is a liability, it doesn't matter whether there's a guarantee. The notification says,
Gupta, since some new points have come, we'll
Yes.
grant you.
all right, very well.
Now let's just get rid of this point because I mean I find it in plain English, but anyway, go to page 27. Let's just answer this point. Just go to page 27. Paras 9 and 10 first.
So already read it to us.
I know, but then it's being said over here that on 8th of November. Now look at his statute. Look at the statutory notification issued by the ministry. Please see this clause 9. Why is the statement being made contrary to the statutory notification on page 34? Look at clause 9 on page 34. Any person who is unable to exchange and deposit the specified banknotes in their bank accounts on or before the 30th of December shall be given an opportunity to do so at specified offices of the Reserve Bank of India or such other facility until a later date as may be specified by it. So this is the government of India making an assurance to all people. And I'm told just now that on the 30th of December, I should have bought a ticket which brought me back into India by the 31st of December.
How did you read?
I mean, this is an astonishing submission by the Reserve Bank of India, contrary to the Ministry of Finance statutory notification.
How do you?
So the whole scheme is that if the Prime Minister says it, the statutory notification says, we are not going to take away your money after 30th of December either. This is what even after 31st of December, till 30th December was given time. But this is a statutory notification on the basis of the Prime Minister's statement. And you suddenly change the goalposts on the 30th of December and you say that now we are not going to do it even if you're abroad. What was I to think when I was overseas? Apart from the points which your Lordship correctly put to me, what I was to think was that, look, this is a reasonable government. I have a constitutional right to property. I have my money which has been withdrawn and which is lying at my home. I'm not required to rush back and spend whatever amounts which are there, provided I get a ticket. I will come back. I came back in February. Now, please go to the statement, therefore. So one part which I'm suggesting now, I'm suggesting to the court that this proviso at page 44 applies only to currency gone out if there is a case made out of a person who has left the currency in India. It ought to be accepted because the proviso has no application. That's my first submission. So please clarify that. That will give a lot of relief to a lot of people. The proviso obviously applies only to people who go out of the country and who come back. That's one reasonable interpretation which can be given. I would respectfully submit, I would commend it to the court. The second reasonable interpretation is, now please go to bottom of page 47. These are the RBI guidelines. Where do they get this from is the question I ask myself. For non-resident Indians. Now, please see, so there is para 3.4 at the bottom of page 46. Your Lordship, see second last line on 46 is 3.4. Please note that my relief which I sought was through that was strike down this insofar as it applies to me. Now in 3.4 the terms are specified, and for non-resident Indians, tenders should be submitted along with the tender form. Roman 2, Roman 3, tenders will be restricted to a maximum of 25,000 per individual depending on whose notes were taken out of India. So again, my submission is all these requirements of certificate of Indian customs on ascertaining that the tenderer was abroad and had a KYC, please interpret this particular set of directions given by RBI as confined to people who took currency abroad, but it is silent on people who left currency here. And I think in my respectful submission, I don't know, I suppose jet-setting lawyers can go up and down the country and buy a ticket immediately and come back, etc. But I think the government of India adopted a very reasonable stand initially when they kept it open because they were respectful of rights. And to answer Justice Gawai's question, I think the presumption has to be that citizens who come and who have genuine cases, if they are able to explain it on the strength of an affidavit, is bona fide and on the basis of passports, etc., and there is no history of them being a history cheater or something, should be presumed not to be a terrorist, someone engaging in trafficking or counterfeiting. I mean, these are amounts which are a huge amount for the individual himself or herself. And to be just, so therefore, I come to the point that this exclusion in the RBI, so that's the next route which your Lordship can follow. Clarify the notification of 30th of December. Another route can be clarify that this RBI notification applies only to situations where currency was taken out and brought in. For those who say that the money remained over here, they must be given an opportunity. Otherwise, it means that there's a huge class of people. Now I'm in terms of the notification. It's a huge class of people unfairly excluded from the process. And it is no answer to say that you had for 50 days to come back to India. It's no answer to say. This is a very patronizing attitude on the part of the RBI that, look, I will issue a notice. And how could I, the submission made was hope of extension. There was no hope of extension. My rights were not founded on a hope of extension. They were founded on the basis that the Prime Minister and the statutory notification issued by the Ministry of Finance on the 8th of November both said that there will be avenues available to you even after 30th of December. And it came through. So why exclude me is the question I ask myself. Such exclusion is completely heartless and completely arbitrary is my respectful submission. Now please go to section 4. Now I'll wind up on section 4 and then a few other small points. Section 4 at page 40, clause 4 of the article, page 40. So does your duty to cover, your duty to have an appropriate notification, does it not extend to situations like us? That's the question. Power coupled with duty, 4.1. Notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such other manner as may be specified by it, namely, please go to Roman 2, such class of persons and for such reasons as may be specified by notification by the central government. So my first submission is excluding a category of NRIs who had money in India is arbitrary in our respectful submission. It is so manifestly arbitrary that it is under-inclusive, going under the traditional classification test. NRIs form a single class. Some carried the money out, some left the money here. Both have to be treated Similarly, you cannot create an artificial barrier or an artificial subclass and extend the grace period only to people who carried money abroad and didn't and declared it in the customs, etc., when they came back. So it is under-inclusive, is my respectful submission under the classical test. It's manifestly arbitrary to exclude us as a whole category. Apart from the other categories mentioned by Justice Gawai, there's so many people who may be medically unable. There is another person over here, for example, whom Mr. Prashant Bhushan represented, Sarla Srivastava. Her husband had died in 2016. And in 2017, January or February, what was it? January, when she was cleaning up some trunk, or what is the correct expression? Steel trunk. She was cleaning up a steel trunk. There was money which was discovered, 1,79,000. It's a lot of money for her. Her husband had died. Now, this is in January. And she wrote to the Prime Minister and said, please help me out, which was referred to here and there. And then now she's in court. And this, therefore, is a very, so that exclusion for genuine and hard cases, I would respectfully submit, puts an even higher duty on the government to be sensitive to such cases and to create an appropriate subsection. So my submission is, central government is wanting in its duty. The second submission is that subsection 2 is in any case a standalone provision. Your lordships have said that we prima facie, I mean at the opening, not after, before hearing them, felt that look, this is something power coupled with duty which even the RBI can exercise. But RBI has also acted in a manner which is incorrect. Now I'm done with this section 4 part also. Now 2-3 small points remain. The first is on judicial review, and I want I'll just sum it up. There appears to us to be a yawning gap of persons not covered, a huge gap. I've indicated 2 or 3 situations. There ought to be at least some broad categories to capture genuine cases such as this. So one part of the argument is yawning gap. The second part of the argument is, in any case, grace period has been extended to all NRIs till 30th June. Why deny it to me just because I kept my money here? That's the second broad argument. Now I'm on judicial review. Judicial review, your lordships know, have been held to be part of our basic structure of our constitution. There's a whole bunch of series of Supreme Court Constitution bench judgments on this point. Now, what's the issue over here? Judicial review is being disabled at 2 levels, and I would respectfully submit, your lordships will have the time to reflect on it and to decide what the correct course of action is. Just take a hypothetical situation. I'm not saying this is the situation here. Supposing under 26(2), the government had handed over minutes and agenda notes and notice and recommendation. And in this hypothetical situation, supposing all 4 of them were blank sheets of paper, what would the court say? The court, does it have the question I'm asking myself is, the part of judicial review and your lordship's oversight, judicial review oversight, limited as it is, surely extends to an informed decision on parts like this. And an informed decision can be arrived at on an issue like this in exercise of your power of judicial review. So the request is, don't diminish the court by allowing them to keep these documents, which are not some high security documents. They are administrative documents. They must be they ought to be disclosed. They ought to be perused by the court. Why? Because it reduces and diminishes the power of judicial review. So please consider that facet as well. And I would be greatly obliged. I think the part on guardrails and to lay down defining parameters is an aspect which survives apart from individual cases like mine, where there may be 1,62,000. I believe it's an imperative. We are way past the stage where you can have some diktat issued by some ruler or something like that and say that what I say is final. No, it is subject to being reasonable, fair and just, whether it is statutory or otherwise under our constitutional scheme. So how is this power of judicial review to be exercised unless these basic documents are made available to the court? So I would respectfully implore the court that please also, as far as guardrails are concerned, and what are the parameters, whatever appropriate expression your lordship would like to use, please use it. The other element is on the question of academic. Your lordship correctly said that your lordship yesterday itself, in the course of Mr. Chidambaram's submission, said that the Bomai case is surely an answer to a situation like that. But there's a useful passage in, the Attorney General referred to a New York Court of Appeals judgment of 25th of September 1877. One of the judgments cited was a New York Court of Appeals, 25th September 1877, in the People versus Amos Clark. And it had a very good line. And I think the reason why the Attorney General probably submitted this was to show the importance of this principle, which was laid down in this 1877 judgment, and how it ought to commend itself to the court. The test laid down by the New York Court of Appeals was, can effectual judgment be rendered? And I believe effectual judgment can be rendered on the overall parameters and on individual cases such as those which have come for the court. So this issue is far from academic. My final point, so it's not moot as has been suggested. Now my final point is that we have submitted written submissions, which your lordships may take note of. It's a written submission on behalf of the applicant. The title has Malvinder Singh in it. It's a fairly detailed set of documents. These were prepared at a certain level before the arguments concluded to give our overall. But your lordships have been very kind and indulgent, and I'm very grateful for a very patient hearing. Yeah, you may consider, therefore, there's one aspect, sorry. There's one last aspect which you may consider. And it's really in the exercise of this court's power. It has nothing to do with the state. I'm now not on what their conduct is or what their actions are. I'm on this court. What did this court do? Your lordship recalls that in the opening I had pointed out Justice Kehar's bench had given them a notice that, look, what are you planning to do under Section 4.2? Your lordships also recall the consolidating order which blocked everything from other courts. Now, let's pause here for a moment. On an issue like this, you might have certain issues where you block access to other courts, which are few and far between. But I think we will all agree that as far as value of currency, your property being taken away without authority of law, etc., all these are aspects which affect these across the country. Now just consider, when the court blocks 226 remedy, which we have all grown up and we all know is an inexpensive remedy available locally. Locally in the sense it's available in your state, right there at the state capital or at the seat of the High Court or the benches of the High Court. Now when you're blocking it, I asked myself, and this is what arises here, effectively what is happening is that only people who can do two things, who have the wherewithal to contact a lawyer who's willing to do it pro bono in Delhi and in the Supreme Court. That's a hard ask. It's a hard ask for citizens, most of us. I was asking myself sometimes that, look, can I find a lawyer despite being in the profession in most parts of the country? I can't in a short while do that. And someone who will do my case, with reasonable competence and free of charge may be very difficult. So I am suggesting to the court that yes, I am primarily concerned with Mr. Malvinder Singh, and Mr. Bhushan has appeared also for Sarla Srivastava, and your lordships may peruse the facts. But having nothing to do with the other side, but having to do with your lordship's own order, having blocked access in all these courts across the country, would it not be desirable for this court at this stage, if you agree with any part of our submissions, to direct that a scheme which is more general in nature than just for me? I'm not saying that they are obliged to do it, but because your lordships blocked everyone from going, how many have come forward? Very few. Isn't it now a corresponding duty ex debito justice, if you agree with our submissions or any part of them, that if relief is to be given, it ought not to be only to Malvinder Singh and X or Y or Z, but it may be for a time frame, but more generally, not because the law requires it, but because your lordship's order blocking access elsewhere perhaps requires it. I'm very grateful. Thank you.
Yes, where is the party in person? The party in person. Madam, you wanted to say something?
Yes, Your Worship, just.
Be brief, huh? Very.
Yes, Your Worship. I just-
But it's a rejoinder.
I know, Your Worship, I'm just saying 2-3 points, that's all, Your Worship. First of all, I'm appearing on behalf of facts cited, Your Worship. Which Your Worship first, I primarily said that maybe that matter will be typed.
This is the other issue.
Wait.
Your Worship, my first submission is that, first of all, we were not allowed from 9th to 14th because we were we were not individuals, Your Worship, we were having a society account. We were not allowed to deposit in
Madam,
this.
we are not considering that cases.
Minutes, that's all.
We are
I'm
not
just
considering those cases.
Just some brief facts only for your notice. Thereafter, Your Lordship, as per RBI instructions, we could not deposit because they were, DCCBs were told not to take our SBNC, Your Lordship. And that is why we could not deposit. So my first submission is, despite our best efforts, we could not deposit the amount. Yes, my learned friend told yesterday that we were given opportunity and we could have opened our accounts in some other banks, Your Lordship. We were not allowed to do that. So my submission is, Your Lordship, even if Your Lordship is de-tagging the amount, there are SLP, there are transfer petition and there are IAs also, which has to be taken into consideration, Your Lordship. And there should be a general order.
All right.
My submission is this only.
All right, all right.
Like-
Yes, where is the party in person? You want it?
There is this order of this honorable board in this particular matter only, in which NABARD was directed to go and they have not gone. I have submitted a written submission on this issue, Your Honor, in my petition.
My banker denied an opportunity to me to make deposit into my bank.
That you have said, no, already you have said.
Yes.
All right, sir, all right. Next, yes, where is the party in person?
Yeah,
Yes, Mr. Sharma, Viplav Sharma.
Lordship, please acknowledge.
Tell us.
My
Be
lordship,
brief.
very
It's
brief.
only a rejoinder. You should be very brief.
Yes, Lordship. My lords, the first thing first is, if your Lordship sees, my lords, as of present, the stand of the Union of India is, my lords, is what was done by them in the previous government was constitutional and righteous, and it was done considering the policy benefit for the whole of the welfare of the country. So, my lords, if that be so, my lords, and if that contention of theirs is held, which, my lords, I'll assist your lordship, and my senior colleagues have already assisted your lordship on the parameters of the law and etc. So, therefore, what they did was right, and they have a right to do it again and again, whichever government comes in. Now, the consequences of this, my lords, is that what has happened is in respect of the currency, which is, my lords, inextricably linked with all the citizens of the country, my lords. So therefore, anything and everything, whatever has been done or possibly would be done after, my lords, whatever judgment your lordship will be pleased to, my lords, deliver, will have, my lords, far-reaching consequences in times to come. So therefore, my respectful submission is this, my lords, that the notification which was issued on 8th November, my lords, that was in respect of, if Lordship has heard submissions for so many days, is in respect of 26(2), which Mallards provided the central government authority on the basis of the recommendation of RBI to be declare a particular any series of currency of any denomination to be no longer a legal tender. Now, Mallards, my respectful submission, what I'm trying to draw a little distinction is the whole issue of currency and the nature of denomination of the currency is distinct and different. With my respectful submission, Mallards, the currency of the country is a rupee, and it is 1 rupee, and that's why if your lordship would see, it is printed as a coin, and it doesn't have any Mallards, the promissory declaration on the coin. So that is the currency. So the currency did not get demonetized. It was the negotiable instrument which starts from Mallards in terms of the RBI Act, which has authority to Mallards print the negotiable instrument act in the denominations of various denominations 2, 5, 10, 100, 500, so on and so forth. Now, Mallards, therefore, if your lordship, Mallards, lordship would be knowing it, but the promise which is made by the Reserve Bank of India is written on the each negotiable. Mallards, I'll just take your lordships to. It says, I'm reading out one of the currency which I have, Mallards, of a 500 rupee note. Mallards, it says, I promise to pay the bearer of the sum of 500 rupees. So it is that rupees which is the currency of the country, which Mallards, the Reserve Bank of India doesn't have authority to Mallards print or mint. It is only done by the Ministry of Finance, and that's the reason Mallards, the Secretary of the Finance has a Mallards signature to authorized the minting of that rupee. So what my respectful submission is that demonetization of the rupee did not take place. The negotiable instrument which was printed by the Reserve Bank of India in a particular denomination got declared to be no legal tender. So that would not mean, because it's a statutory, as my colleague Mr. Diwan has argued at length.
Mr. Sharma, all these points have already been argued. What do you want to say in reply? Tell us directly come to the point. All these arguments have already been made, you know.
Yes, my lords. My lords, what I'm
You
saying.
also made this argument.
Yes, my lords. My lords, I would not.
What is there in reply if you?
Lordship, what I'm saying now here is there are 3-4 points which I'd like your lordship to consider.
Come to the point. What point you want?
Yes, my lords. As regards to the first, just for the records, my lords, as regards the any series, any denomination point, my lords, that your lordship will find in my petition expressly urged by before your lordships, my lords, and it is in the grounds, my lords. I tell your lordship the grounds is. Lordship, may kindly make a note. It's ground H and I at page 33.
All right.
This is specifically urged, though possibly what petition which Chidambaram argued, writ petition number 916, maybe it is not specifically contained, but it is contained in my lords writ petition specifically. Ground H.
Right.
Then, my lords, I have to say, my lords, that 26.2 has to be tested on the touchstone of the whole scheme of the RBI.
That is also argued. It was argued at length.
No, my lords.
Don't repeat in reply. Yes.
With this argument, I'm, my lords, trying to tell your lordship a different point. What I'm saying is, if your lordship will kindly consider section 17 of the RBI Act, so it basically provides two facets, that section 17. Now, it provides whole of the banking, which involves the money in terms of, my lords, the denomination which is there, and the banking and banking related money transactions. The whole of the section 17 is very elaborative. It talks about how the physical operation of the country will be manned in terms of section 17. And that section 17 also provides that it will be also the duty of the Reserve Bank of India to manage, print the currency, and accordingly 26.1 and 26.2 is also there, and 24 is there, printing and giving us legal status also. So the point I'm trying to make it here is, the minute that notification came in, the whole of the section 17, operation of the whole of the section 17 was rendered OTOs. That's what I'm trying to suggest, your lordship, because the whole banking got haywire. There are various RBI notification to the effect which I have placed on my record, and there are various other petitioners who would have also placed that the whole banking could not take place.
Sharma, what do you want? What do you want to say?
So what I'm saying is that
what is that you want to convey?
The point I'm trying to make it is that
Sharma, all these questions have already been argued.
No,
Please close. Please close. You are in rejoinder. Please close.
Okay, Malats. Then second thing is that on the notification issue, your lordship was very specifically, Malats called upon the Union of Indian Attorney General on the Malats, the constitutionality, as because that notification was not issued in the name of the President of India under Article 77. The Attorney General
that we have noted. Please proceed.
No, what I'm saying is that AG has not responded to your lordship's query.
All right. We will ask the AG. Now you please proceed.
Opportunity is Malats gone. Then Malats may say, then lordship may kindly have my petition for me. Only one ground which I want to urge. Lordship may have page 36 for my petition. Only one submission. Then I'll be done with that. What I'm saying is, Malad, if I may be permitted to read, Malad, a few lines, Malad, for my grounds.
Read.
What I'm saying, it's ground L, Malad. The demonetization of any currency is completely beyond the scope of Reserve Bank of India, Act 34, which is relatable to entry 38, Reserve Bank of India of list 1, given list of the 7th schedule of the Constitution. The demonetization of any currency, which is as reported 86% in circulation in the whole country, by way of declaring the whole of such currency to be ceasing to be a legal tender, is completely outside the domain of the Reserve Bank.
So Sharma, this was repeatedly argued by many, by almost all learned advocates.
My respectful submission is, that the demonetization will take place under the Act of Parliament in terms of Malut's entry 38, not under in terms of the.
It has been argued by everyone, not once, but more than
Many times.
Malut's
All
another.
right, all right, we will conclude. We will.
Malut's, may I seek your lordship indulgence to file my 2-3 page written submissions?
All right, that we will permit you. We will permit you. All right.
We'll just ask Gupta and
Veji, though after reply there is no provision to hear you, but if you want to say something, you can. Take 2-3 minutes, and if you have to make, thereafter Gupta can respond, or one of you. Choice is yours.
Mr. Gupta wanted to say something first, I will try to conclude.
You can, you can.
Milord, this question which has been raised today, Milord,
Ah.
I believe, Milord, it is not really necessary for us to go into it. But since it has been raised, Milord, let me try and answer it. Give me the statute. Now, Milord, what has happened is, in 1946 legislation and 1978 legislation, the second stage was not indicated. Milord, presumably, Milord, on the understanding that when legal tender comes to an end, section 34, which says in circulation, also, Milord, comes to an end. On that basis, Milord, it seems to us that the legislature did not provide what is in fact provided in section 3. But, Milord, it is our submission that it is not necessary to have that confusion. That is why this time around, they specifically put it in. They noticed it, and so they specifically, Milord.
even in 1946,
Yes.
26A has been subsequently introduced.
That's correct. So therefore, Milord, to the extent 26A takes care of it, Milord, no difficulty.
1946.
Yes.
46. 1978 is not taken care of. So, Milord, it is my impression, Milord, that they must have been under the impression that on a correct reading of section 34, once it is withdrawn as legal tender, those guarantees and that liability goes because the notes are no longer in circulation. But in this case, Milord, we don't even need to go there.
No, that is not the way. What happened was, since there was a window provided for exchange, unless the liabilities get reflected in the books of the RBI, they could not have exchanged.
Yes.
Therefore, it continued.
No. So I understand, Milord, the submission that this is because there is a liability. Now, it does not necessarily have to be because of that. It can happen simply because the notification says that it will be exchanged. That's an independent obligation.
Though it suggests to have a status of a legal tender.
Yes.
In view of the provisions made in the notification.
Correct.
It has got till 30th of December, it could be exchanged.
It could be exchanged. That is enough. It is not necessary, my lord, to delve on the theoretical basis on which this notification
In
is.
any case,
Yes.
in view of the ordinance of 30th of December.
Yes.
It suggests to have any status from 31st of
31st of December, my lord. No. So therefore, this question, my lord, by itself is not today very important. But, my lord, my learned friend would like to really submit, as far as I have understood, that because it was alive till 30th, therefore there was no sufficient time given. But, my lord, what we are forgetting here is, my lord, that the first notification itself said, do it by 30th.
Yeah, that is.
Yes.
And then it said, there are these subsequent conditions. That's all.
He relies on clause
9. Sub 9.
Clause 10.
9, my lord. Page 4.
Sorry, 9.
9, yes.
Clause 10 of the press information.
But, my lord, we have to start with the beginning of paragraph 2, which says that the specified banknotes held by a person other than banking companies may be exchanged at any issue office, etc., for a period up to and including 30th December, subject to following conditions. Now, my lord, what is the normal reaction of a citizen of this country when he faces this? If my lord, 9 is the governing, my lord, clause of this, my lord, paragraph, then please see, it will not stop with NRIs. It will not stop with NRIs who have left money in India and gone away. Every individual, my lord, who thinks he can make out a case that he was unable to deposit the money, will come and say that a mandamus has to be given to enforce 9. The deadline will vanish forever for everybody.
Mr. Gupta, repeatedly Prime Minister, Honorable Prime Minister's speech was,
Millard,
you know.
I know, Millard. Now, Millard,
But can you just come to page 26?
Yes.
26, I think all this para 1, 2, 3 have to be read together. Just read that 2, 3 sentences.
I'm sorry,
In that
Millard.
compilation of
Notifications?
Compilation of Mr. Ivan. First compilation.
You can't open it from there. Give me the copy.
you have this.
First compilation containing all the notifications.
Yes. Millard, we've also given, that's why, Millard. Millard, your lordship is looking at page 26 of this compilation.
26, last sentence you read, persons holding.
Yes.
Read 2, 3 sentences. Let us read together.
Yes, Millard, I'm just wondering what
Persons holding.
persons holding old notes
Read.
in Malvinder Singh's compilation.
Read.
Persons holding old notes of 500 can deposit these notes in their bank or post office accounts from 10th November till close of banking hours on 30th December to 2016 without any limit.
Next sentence
Yes.
also, very important.
Thus, you have 50 days to deposit your notes and there is no need to panic.
And
50
next
days.
sentence.
Your money will remain yours. You need not to worry on this point,
Therefore-
provided you follow the law.
All have to be read together, perhaps.
Let's suppose you read it together. Suppose we read it all together. What is this assurance said? It has said that if you follow the instructions which have been given to you, then your money will remain safe. You will not lose anything.
50 days time, even the
50
Prime
days time. He
Minister
has mentioned
said that.
50 days there. He has not said that I will give you enough time later on also, not just 50 days. But even if he had, Millard, this is a statutory notification. Now that statutory notification, there is no case which can be made out that there is some kind of a promissory estoppel that this statutory notification will be extended. What is the legal cause of action here? And Millard, I keep, Millard, asking myself, what would a person normally do? He can come back in February, but he can't come back in November. The cost of the ticket is the same. He has not written, Millard, we have checked. He has not made any, sent any mail during that period.
That you already said, Mr.
Yes, Millard, those are facts. But here, Millard, what I am saying is that the notification itself had provided 30th of December. And what happened was a limited window of opportunity was opened, no doubt. But that opportunity, Millard, the legislation did not want to open it any further. So, Millard, Parliament did not want to open it any further. Not.
Clause 2.
Yes.
Of section 1 of section.
To the
central government.
Yes, but even the central government decided not, because Millard, your lordship knows the climate of that time, Millard. There was a feeling, Millard, that some of the provisions were being misused. So if under those circumstances, the legislature and the central government did not want to open a larger window, Millard, there is nothing that can be said about that. Now,
No, but the parliament in its wisdom
yes,
had thought that there may be such class of persons and for such reasons as may be specified,
yes,
that the central government may need to give some kind of a relief.
correct, Millard, but the central government in its wisdom has thought that they won't. Now-
Even now, this
Yes.
law is still there. Even now, central government.
Millard, look at section 6, section 5 for a moment. The person who, contrary to the authority of law, has held those notes is today to be prosecuted if he comes up with notes. Look at section 5.
Then how do you deal with situation where that widow found some money after her husband died?
Millard, it's very difficult, Millard, to deal with every situation like this, Millard. Because if you question is, under that subsection 2,
Yes.
can the court, Millard, now give a mandamus, as my learned friend is asking for, to formulate a scheme? They are saying you formulate a scheme, we or central government, whatever. Formulate a scheme to give a very large class of person, which he says is huge, opportunity to hold on to submit notes even today. Now see section 5.
So this is for the central government to take a
It
call.
doesn't matter, Millard. I'm not, Millard, going on that.
Yes.
My learned friend will deal with it. But please look at section 5. Millard, I'm not going to, Millard, continue this submission. If my learned friend wishes to, Millard, say anything, Millard, he will. Section 5, prohibition on holding, transferring or receiving specified banknotes on and from the appointed date. No person shall knowingly or voluntarily hold, transfer or receive any specified banking notes. And then, my lord, certain exceptions. Then penalty. Whoever knowingly, willfully makes any declaration or statement, etc., which is materially false, etc. And 7, contravention of section 5. Whoever contravenes shall be punishable. Now, my lord, which citizen, my lord, can be encouraged to say today that I have held on to these notes in the hope that the Supreme Court of India will vary the law? It just cannot be. They are under a duty to look at the law and follow its, my lord, dictate. My lord, so therefore, my lord, this.
No, Mr.
Yes.
Gupta, before proceeding.
Yes.
Now, we were talking of this 10th November till the closing of the bank hours on 30th December 2016.
Yes, my lord.
Then 50 days to deposit.
Yes.
Then your money will remain yours.
Yes, yes.
Now, this 50 days to deposit, because I'm not clear, I'm just.
Yes, my lord.
Was there a limit to deposit the amount?
No.
Or any amount what you held could be deposited?
Any amount, you are free to deposit any amount.
On a single day, on a single day.
On a single day or on multiple
In
days.
the account, KYC compliant.
KYC compliant account.
The limits are only on withdrawal of the amount.
Limits are only on withdrawal, and my learned friend Mr. Chidambaram was right. Up to 4,000 rupees could in fact be exchanged. By giving 4,000 rupees, you could get 4,000 rupees of new cash, but not in excess of that. The rest of it, my lord, will get credited to the account, KYC account, and you will be entitled to withdraw it in accordance with whatever be there
Whatever guidelines were
in place at that point of time.
4,000, it was increased to 10,000 from.
And then 25,000, etc., etc.
There was no outer limit insofar as deposit.
Deposit is.
No outer limit whatsoever. And that is so even for the NRIs.
But anybody who has money beyond the known sources of income.
Right.
Not have deposit.
When
Yes.
unlimited deposit.
Yes.
Subject to invitation from the IT department.
But there has been. Millard, there has been. It has been followed up by income tax investigations.
My learned brother ads and ED.
So
I won't,
that's why
I'm
they-
not commenting. Millard.
They deposits in other person's
Yes.
account.
Millard,
They made deposits in
consequence that you will face. So people would, Millard, only go to the bank and deposit such amount as they know that they are holding legitimate. They did. Some people got away with it also, Millard. But not everybody got away with it. The point is, Millard, that in law, all legitimate cash that you had could be exchanged up to 30th December. Guarantee. Beyond that, Millard, we didn't give any guarantee.
All right.
And Millard, the second thing which my learned friend says, eliminate the proviso in that notification,
Yes.
which is dated 30th December. He says that eliminate this proviso in relation to a particular class, namely NRIs who went abroad and left money in India in excess of 25,000. Now, Millard, on what principle of statutory interpretation are we going to read down this proviso to that limited extent? There is no provision, there is no principle of statutory interpretation by which this can be done. He is, Millard, saying that in equity, do it. Because there is such a case.
142, 142.
142, yes, Millard. Millard, I am not opposing your lordship's, Millard, exercise of powers under 142. In fact, each of the special cases which are before your lordship, if your lordship wishes to look at the facts, Millard, and take a decision, Millard, we can have nothing to say about that. So that's the next thing, Millard.
Yesterday you made a statement.
Yes.
That insofar as Mr. Diwan's client is concerned,
Yes.
he had not even made a representation to the
Never.
RBI.
Never, Millard. Not within that period. Milord, he came back and tried to, Milord, make an application under 4.2, but that was not received because it was not in the format.
All.
And he could have filed an appeal also if it was within 4.1. Milord, if it is not within 4.1, it is our contention that he could not have made an application. And Milord, I've already, Milord, made those submissions. So therefore, the proviso, Milord, cannot be read down as has been suggested. And the final thing is, Milord, the guardrails, Milord, submission that it is no longer possible to issue diktats. I agree. But guardrails to limit, Milord, the possibilities of economic policy making, Milord. Is that, Milord, part of our basic structure? That's not. And finally, Milord, my learned friend says that it is because your lordships withdrew the jurisdiction under Article 226 and brought all the matters to this honorable court, therefore the date should be reopened. Milord, I have not followed. 226 would have given him this relief. Your lordship has withdrawn it, so your lordships have the jurisdiction now to give that relief. Milord, the withdrawal is not a reason for suggesting that today there should be a scheme. It doesn't follow from the fact that your lordships withdrew it. Because the High Court's powers were there, now the Supreme Court's powers are there to exercise it. In fact, if anything, he gets a benefit by this withdrawal for two reasons. One, those persons who had come to court were given some kind of an assurance that sections 5, 6 and 7 of the Act will not be applied against them. And the second is that they have got 142. High Court could not have given them that relief. So, Milord, I do not see, Milord, why your lordship's order withdrawing all matters to this honorable court should be the basis on which a mandamus should now be issued, giving, Milord, directions to have a scheme. Milord, and Milord, I'm quite alarmed that my learned friend thinks that there is a huge category of persons who are having a grievance, because that's not evident to us, because the number of complaints is very finite.
All. Yes,
Yep, yep.
Attorney, you want to say something?
I shall be very brief, Your Lord. And I can't catch up with the speed and sound of my learned. Not here. I will wish you 3 points. If the clock had stopped with a notification, we would have all kinds of arguments on the legality, the limits of the notification. How do you read 26, 26.1, 26.2, cessation of liabilities, and so on and so forth. But as it has happened in this case, different from what happened in 46 and 1978, it has happened in 2 stages. The government, on a recommendation received from the RBI, issued a notification. Did not happen in 46 and 1970. And in the ordinance, when it says we want by way of abundant caution, the ordinance says in the preamble, to have clarity and finality on this question, we say also deal with the question of liabilities. Anything said by way of abundant caution is not wrong. It only tries to clarify the position. You can't pick up an argument from it and say, look at what they're doing, and try to build an argument of interpretation on 26.1 and 26.2. I don't want to get into the question of 26.1 and 26. It's a built-in scheme. Built based on 26.1, 26.2 follows. So both are integrally, intrinsically connected. I have the power to say this is legal tender. I have the power to say it will cease to be legal tender. The limitations are built in 26.2. We don't have to go beyond that at all.
Once it ceases to be a legal tender.
That's right. 34 is for a different purpose. As long as it remains a legal tender, during that period, what is the position of banks, RBI's banks of accounts? That's the only limited operation 34. But 26 is the overarching provision. It is not dwarfed by section 34. As long as 26 does not come into operation, 34 will remain.
Once it ceases to be a legal tender, then it ceases to be in the circle.
That's right. Before 26, as I said, yes, it dwarfs section 34 when 26 is invoked.
Except for
That's right.
period extended for exchange.
Exactly. It is built into it. I mean, whether you treat it on the basis of contract or not.
After 8th of November, it would be between 2 persons. The transaction will be invalid. It suggests to be a legal tender.
Absolutely.
That could, the liberty is only granted to deposit it in the bank. With the bank, and
That's right.
KYC compliant.
That's right. That's right.
But Mr.
That's
Mr.
right.
Ramani could not have given an amount to Mr. Gupta after that period. Legally.
There's no private transaction as
Private transaction.
no private transaction.
Exactly.
So his argument that even after that, the private transactions could have been done on the.
You have to read it into 26.2 as if a fresh legal principle built into 26.2. I don't think you can do that.
That is what his argument was.
No, he didn't argue.
The second thing is about, I don't want to traverse again, this,
He could not.
the notification subsequently issued in pursuance of section 4, where the parliament said there can be a grace period. And once a grace period recognizes certain categories of persons, residents and then non-residents, will ordinarily carry cash and come back with cash. When my other friend says, no, here is a casus omniscience, right? The parliament the notification omits a very important sections of people who go abroad for deriving a benefit of being an NRI. I mean, I wish we preserve the dignity argument to more precious cases. An NRI wish to go abroad and wish to get a benefit of being an NRI, wish to derive a financial benefit. He doesn't want to lose that financial benefit. He says, oh, don't drop my dignity. I'll have a financial benefit. And you want to get a financial benefit, you are robbing my dignity. I think they were misconceived. There's no dignity involved in it at all. That's why it's important for us to say dignity is operates in an entirely different sphere. Your personal dignity is involved. Your privacy is involved. So when you try to extend this kind of argument, it simply breaks down. The virginity of the arguments breaks down. I say there is a limit to that. The last is about the Prime Minister's statement. So when the Prime Minister makes a statement, kindly look just one reading, I keep reading it again and again. Page 27, paragraph 9. I mean, there can't be an argument of estoppel on a statement like this. I wish there's an estoppel against.
That is only an aid for construction, perhaps. The speeches made in the parliament.
That's one way of looking at it. It was at a time when the notification to section 4 has not come.
Oh.
So that's why the Prime Minister said there may be someone for some reason, good reason, a legally acceptable reason, legitimate reason. Therefore, you want to say, I will not forgo my NRI benefit. Should the state step back and say, well, there is a very good reason for that. I should have accepted it. Therefore, it is no ground, no case been made out on that. And finally, on my 3 point, my argument on paragraph 2.53, a lot of things have been muddled up. I don't wish to give back in the same coin. The argument is after the notification, if the parliament sits back and says, look here is the notification under 26.2. Parliament debates it. Parliament takes note of it. This is the first time I've seen that when a notification is referred to by a parliament, and therefore the parliament, that's why I said very decidedly, the parliament gives a stamp of approval to it. I did not say it's a validating legislation. I understand the difference between validating legislation and the parliament validating it by looking at it. Therefore, a considerable thought process has gone into parliament when say, I look at the notification. The parliament could have need not have referred to the notification. Need not have. But when the parliament refers to it, you'll have to attach some importance to parliament looking at the notification. Will you completely efface it out? My answer would be no. That's about all. Lordship, please.
And Mr. Jaydeep Gupta, we are reserving the judgment number 1. We are granting you time, whoever wants to file written submissions within 2 days. But please pass on the records if you have right now, both of you, if you have the records, or else by today evening you can submit the records.
Yeah, I'll put it.
Whatever, it is a perusal of the court.
Certainly,
For
certainly.
the perusal of the court.
Certainly, sir.
If it is readily available, give it now.
I will have it arranged.
Or by evening you can.
I will have it
You can give it
I will.
for our perusal.
Certainly.
If you want, you put it in a
I'll
cover.
put it in a seal.
Seal cover.
I'll do.
You can put it. Both of you, please give the record, whatever records you have.
Only one small thing. The affidavits are virtually captured to a large extent.
No, let us have the
But,
satisfaction.
no, I'm not saying no. I will be saying that, yes, your lordships may have look into it.
Yes.
And it may aid, probably it may aid.
Yes, yes.
Whatever arguments have been placed before your lordships. I'll certainly do it.
Do it. Thank you so much.
Lordship,
Liko.
Lordship, yes, Lordships in 501.5.
Just 1 second, sir. 1 second. Just 1 second. Mr. Sharma, ML Sharma, what do you want to say?
I want to say only, I want to take 1 minute of the court, only 1 minute, Your Lordship.
Take.
Your Lordship, the entire issue is confined to the decision of the President. That's
All
why
right.
I have
Don't
challenged.
repeat all those things.
I
Don't
will not,
repeat.
no, I will not repeat. No, Your Lordship, I will never repeat. That's my undertaking. And that answer AG has not given yet, and they should give.
All right.
I wish to give only 2 citations in response to
Because,
this.
because Article 1110 is much.
All right.
Now he's answering your.
Yes, sir.
The first one is
With permission, my lord.
1975.
With permission, my lord, I am taking only 30 seconds, my lord. My
Wait,
case
sir.
is this,
Wait,
my
sir.
lord.
Wait 1 second. Wait second.
1975, 1 SEC.
Sanjeev Naidu.
This is, no, Sanjeev Naidu it comes a little later. 763, 1 SEC 763. Then the next one is 2003, 6 SEC 277. Both are in respect to the Article 77 argument. We made that argument. But as far as 110 argument is concerned, I think it's misconceived. It doesn't warrant a response.
All right.
In my
What
case,
about the Article Exodus?
All right, sir. All right. We
in
will
my
consider.
case, my lord, applicant father was died due to sudden announcement.
We have understood. We have understood.
In my, I'm taking only 30 seconds, my lord.
Huh.
Applicant father was died due to sudden announcement, my lord. Thereafter, whatever money is received by the LR, they deposit in an account and they are facing the prosecution, my lord. This is the case, my lord. And if the announcement is not supporting the law, then we are entitled for compensation, my lord.
All right, sir. All right. Now you're right. Now over. Now you're right. All right.
Lordships, we had submitted that our money was lying deposited in the court before the MM in Rohini. And however, despite several applications filed before the MM, he did not release the money.
Sir, we have told you all these factual aspects will be, have to be decided after we answer these questions. We are not deciding factual aspects. We have been repeatedly telling you.
Lordship,
Over.
On the written submission, lord, lordship can give time till Monday.
No, sir. We can't. Give it by Saturday.
All right, sorry.
Heard, judgment reserved. Written submissions, if any, on or before Saturday. Date. What is the date? Saturday? Give the date.
10th December.
10th December. Learned Council representing the respondent Union of India and Reserve Bank of India are directed to produce the relevant records.
Your Lordship, I put it in a sealed cover. I'm grateful to your Lordship.
Thank you so much. You have learnt a lot. Very Champion is not here. Please convey our.
In fact, Mr. Chidambaram read out some passages from Mr. Rangarajan's book. I told him that I've also read that book. There's something which I can say. I don't want to trouble your lordship more with that book.
All right. Thank you so much.
Yes.
Lord, I had taken, Lord, I was trying to emphasize
Yes.
on the fact, Lord, that the judgment starts, Lord, with corresponding rights on humans and then adds, Lord, those 5 freedoms.
Yes. Yes.
So, Lord, first was that the judgment says, Lord, that there are rights in the animals on account of duties on humans. Those rights are statutory rights, and those rights have to be read with fundamental duties under 51A and the 7 freedoms, the 5 freedoms. That's, my lord, the ultimate conclusion of this judgment. I'll repeat it. Because there are duties on humans, there are corresponding, quote unquote,
Yes.
quote unquote, corresponding rights in favor of animals. They are statutory rights under 3 and 11.
Yes.
They have to be read along with the 5 freedoms.
Correct.
And, my lord, what flows from fundamental duties under 51 capital A. And in fact, I will show you, my lord, that now the judgment says that when you read the so-called rights under 3 and 11, you will read into them. You will read into them, my lord, these freedoms and 51A. This has 2 or 3 problems. One.
But, Mr. Rohadgi, the question we are determining, how does it really matter whether this is the whatever the Bullock Sahib is in the nature of right or not? Even if we say humans have duty to do or not to do something, so far as the judgment is, the litigation is concerned, it will have the same effect. Whether you hold that animal has right or not, or humans have obligation or not.
With great respect, the entire judgment from the beginning proceeds on the premise, and I show you a passage that in this case, the Supreme Court says we are concerned only, my lord, with the rights granted to animals and nothing to do with humans. How can, my lord, you have an approach only of animals and not with humans? My lord, that's the answer to your lordship's query. It's a very important question. Turn to para 15. 1.5. If you ask me, my lord, with great respect to the learned judges, they have done a lot of labor in this case, no doubt about it. But, my lord, the entire approach is skewed, my lord. Turn to para 15. 1.5 at page 562, my lord.
Just be mindful of the clock also.
Yeah, I know, my lord.
We have to.
I know, my lord. I'll try. Yeah, as fast as possible. Lord, I don't
Yes,
want
sir.
to spend a lot to say. Para 1.5.
Yeah.
We have to examine various issues raised in these cases, primarily keeping in mind the welfare and well-being of animals, and not from the standpoint of organizers, bull tapers, bull racers, spectators, the participants, or the state of the center, since we are dealing with the welfare legislation of a sentient being over which human beings have domination and standard we have to apply deciding issue and a species-based basis subject to the state. With great respect, you can never have, half a picture. The courts are dealing with humans. and how humans are behaving. How can you say we are only talking about the rights of some species which are not humans? If you ask me, Milord, with great respect, you ask a wrong question, you'll get a wrong answer. This is the wrong question. Milord, thereafter, kindly turn to 42, Milord. 42. I will not read 4-5 paragraphs and then make 2-3 submissions, Milord, on this judgment. 42, Milord, at 585. Sections 3 and 11, as indicated, confer no rights on organizers of Jallikattu or Bullock, but only duties and responsibilities. But confer corresponding rights on animals. Please mark this line. Milord, this line comes without any discussion, without any reasoning, and I submit without any rationale. And, Milord, your lordships have held, in Justice Sahay's words, Milord, one of the best judgments on per incurium, Milord, and sub silentio in that alcohol case, Milord, synthetics and chemicals, Milord, I draw your lordship's attention. That what is, Milord, recorded as a conclusion, without discussion, without precedent, borders, Milord, either on per incurium or sub silentio, and cannot be a declaration of the law under Article 141. That's what, Milord, your lordships have gone to the extent of saying, Kohe Supreme Court, not High Court. So this, Milord, saying that you read 3 and 11, it's a duty on the obligation on the human being not to act, Milord, if I may say so, excessively, which will lead to a sanction, but it will lead to this. There is no warrant in the statute, Milord. Especially when you are conscious of, Milord, fundamental duties which themselves can't be enforced. If it can't be enforced by humans against humans or against government, this proposition, Milord, you will read this proposition by some process of reasoning. Not there at all. Now come back, Milord, to what I was reading. I had read, Milord, 64, 65 to your lordship. Come back to that for a second. 64 was those 5 freedoms, Milord.
Yeah.
I read, Milord, kindly see placitum D. These 5 freedoms are considered as fundamental principles and welfare, and we can say that these freedoms, kindly mark, Milord, find a place in 3 and 11, and they are for animals like rights guaranteed to citizens under Part 3. With great respect, Milord, doesn't follow at all. Part 3 are rights given by humans to humans by a constituted assembly. Then, Milord, 66. Rights guaranteed under 3 and 11 are only statutory rights. Same have to be elevated to fundamental rights as done by few countries. Rights and freedoms granted to animals under 3 have to be read with 51A GNH, which is the Magna Carta of animal rights. Milord, I respectfully submit there is nothing in 51 to suggest, Milord, it's a Magna Carta. Now, Milord, kindly turn the page. Turn to 68, Milord. 51A subclause H says, it shall be the duty of every citizen to develop scientific temper. Please underline the phrase humanism, the spirit of inquiry and reform. Emphasis has been made to the express humanism, which has a number of meanings, but increasingly designates as an inclusive sensibility for our species. Humanism also means to understand benevolence, compassion, mercy, etc. With great respect, Milord, I have checked a couple of dictionaries. No dictionary has the meaning of humanism which is mentioned here. And I'll show you, Milord, one by one.
Yes.
The mistake is that their lordships are thinking humane. Humane and humanism are completely different. Humane is have a humane approach, have a merciful approach, compassionate approach, be humane. But humanism has nothing to do with it. Humanism is a rationalist who doesn't believe either in religion or Milord in some supernatural power. He believes in rationalism. That is how Milord it is defined in every dictionary. I can read it, Milord, but may not be necessary. But I can read one. A system of values and beliefs based on the idea that people are good and problems can be solved by using reason instead of religion. A belief based on principle that people's spiritual and emotional needs can be satisfied without following a god or religion. Being a rationalist, borders on being an atheist. That's how it means. Rationalism. There is a large number. Anyway, so Lord, that's how it is. Now, Lord, your Lordship sees the last portion of 68. To look into the welfare and well-being of animals and the duty to prevent infliction of pain or suffering on animals highlight the principle of humanism in 51. This is not correct. Both articles G and H have to be read into 51, especially into 3 and L, and to be applied and enforced. Now pause here for a minute. Because fundamental duties can't be enforced. Your Lordships have said repeatedly, Milord. Now it will be enforced by being, Milord, welded into 3 and 11. That's yet another error. 51 is enforcement of fundamental. Milord, if your Lordship desires, Milord, your Lordship can note. It is settled law, but your Lordship might just note. Fundamental duty is not capable of being enforced, Milord. 2002, 1 SCC, 428, and that directive principles can't be enforced, Milord, was said long back. Directive can't be enforced, AIR 58, Supreme Court, 731. Now, Milord, your Lordship will find. Kindly turn now to 595, Milord. Milord, with respect, C71, Milord. We have, however, lot of avoidable, non-essential human activity like bullock cart race, jallikattu, etc. Pause here for a minute. How does the court decide, Milord, that it is, Milord, essential or non-essential? How? It's a part of culture, it's a part of amusement, it's a part of religion, whatever it is. The court is not an arbiter of deciding, Milord, whether it is non-essential or not. Can you say, Milord, walking in a park for a human being is non-essential? He need not walk, he need not run, he need not do this, he need not do that. How do the court say, Milord, it is non-essential? So you start with this, that what you are doing is really non-essential, you are doing for amusement, and therefore you are causing, Milord, this kind of pain. But thinking that they only instrumental value are intentionally used, though avoidable, again avoidable. Ignoring welfare of bulls solely for human pleasure. I showed you 11M. 11M can solely be entertainment. There's nothing wrong with it. Lord, when you ride a horse, it is solely for entertainment that you ride a horse. After domesticating a horse, you ride. You can't do it without domesticating. I'm going to show something else, Lord, a little later. Now turn to 72. 72. Every species has a right to life and security subject to the law of the land, which includes depriving its life out of human necessity. 21 of the Constitution safeguarding rights and protects life. In the word life is an expanded meaning which include forms of all life, which is including animal life, which is necessary for human life, fall within 21. So far as animals are concerned, in our view, life means something more than mere survival. This judgment of the Supreme Court that life means mere survival was meant for humans, not bare existence. Your Lordship would recall. It was not meant, Lord, in this form. Now go further. But to lead a life of intrinsic worth and honor. Animals' well-being and welfare is statutorily recognized under section 3 and 11, rights framed under the Act, right to live in a healthy and clean atmosphere, and right to get protection from human beings against infliction of pain is a right guaranteed 3 and 11 and 50. Now, my lord, your lordship sees again in 74.
Yes.
Again in 74, your lordship get an amalgam of 3, 11, 51A, G and H. And if so read, last line of 74, wolves cannot be used as a performing animal since they are basically draught and pack, not anatomically designed, etc. etc. Yeah. Lord, one more comment I wanted.
Just wanted you to read section 7 and 8 of the Environment Protection Act. So these are duty cannot be enforced. They're just wondering, if you read section 7, 8.
Yeah, I'll read it.
And a writ is filed for a mandamus asking that you shall not.
No person carrying on an industry operation process shall discharge or remit or permit to be discharged or emitted any environmental pollutant in excess of such standards as may be prescribed. No person shall handle or cause to be handled any hazardous substance except in accordance with procedure and after complying with such safeguards.
So in a public interest litigation, let us take it. Find that the industry is doing precisely, the duty is there. Mandamus lies where a duty, perhaps it becomes a public duty because it affects the public. Will it not lie? I mean, petitions are filed.
This is statutory. No. The first issue is, it is between humans.
That's right. Supposing, take a case where in a local body, a case is filed that animals are being treated, say dogs, as a very controversial issue, Kerala in particular, we know that. Or any other species, for example, they are treating the officers of the particular local body, they are treating them in a very cruel manner. Assume, hypothetically. Can a writ be filed by somebody saying, please don't do that? And a mandamus is issued to the officer, the chairperson of the authority. Please ensure that the duty under section 311 is enforced.
With great respect, in this example, it may be difficult for a court to tell the owner of an animal that you must ensure that the animal is fed in a particular manner, not chained, kept in a shed, not kept in scorching sun. That may not be possible. The position of environment and that may be different. This is an environment being spoiled by a human being to for a human being. But because rights are enshrined for human beings in our constitution and our laws.
That's right, but it is ought to be enforced against humans because cruelty.
But at whose instance?
I think it's the very person.
No,
any local, anybody.
I'm only saying, that it is being enforced against a human, but at the instance of an animal.
That's right. Yes, on behalf of the animal.
On behalf of the animal.
On behalf, where is that behalf? Where do we get that?
Lucas.
Somebody would say, some law would say, this law says there's an obligation on you, Mr. So-and-so, not to inflict extra pain because if you do, you will be sanctioned. Fine. That it stops there. There is no law saying that there is a corresponding right in an animal to do this, that, or the other.
Take the case of, say, the degradation of a forest, wildlife protection, or the Forest Conservation Act. Can you not come and say, can a human not come and say, see, it is happening there, a lot of people are they're violating the law, cutting trees. Preservation of Trees Act you have in every state.
Yes, yes.
Trees cannot be cut. Whether it gives the right is a different matter. We are not talking about that. But a duty to not actually do certain acts as are laid down in the various acts would perhaps be enforced by a mandamus.
The only difference is could be. The only difference, seems to me to be in the case of animals versus humans, as opposed to the environment or other, which is for humans by humans. That seems to be the difference. And in any case, this is a matter of debate. It can't be in this fashion that if you have this duty, you have a right statutorily enforced, then 51A is enforced. How can 51A be enforced? We don't look at it anyway. 51A is being enforced. by putting it into 3 and 11. 51A itself for humans can't be enforced. It may be a matter of debate, as my Lord Justice Joseph has put it. Yes, it could well be, but you have to have a debate and then work it out. Can't be, my Lord, in this fashion.
Yeah.
It's not A is equal to B and B is equal to C, hence A is equal to C. Doesn't work like that. Doesn't work like that. The entire judgment is founded on that.
Observation.
70 last sentence.
1-7, my Lord.
No, 70.
7.
The last sentence. Further animals like cows, bulls, etc. are figuratively used for farming, transporting loads, etc. That too for the benefit of human beings.
Yeah.
Then of course subjecting them to some pain.
Yeah.
That is unavoidable. Now the question is, now whether the preservation of culture,
Yes.
whether that can be said to be for the benefit of human beings, whether that will fall under there.
Lord, culture would be a part of a human being's well-being.
Because they are the
part
they
of
are
somebody's
the
well-being.
why
What else is culture?
Why this question is put is
Yes, sir.
farming, transporting loads, etc. So here whether this will fall there under preservation, whether it will be for the benefit of a human being.
Lord, culture would be a part, and this would take color from Article 29. 29 uses the phrase that the people will have a right to conserve. It's a very peculiar phrase, my Lord. It doesn't say protection or promotion, which would be normal promotion of culture. It says, my Lord, any section of citizens residing in territory of India or a part having a distinct language, script or culture of its own shall have the right to conserve. It's a right to, it's an absolute right to conserve. Just as you have a right of farming, you have a right, my Lord, of conservation. I am grateful for that query. Now, my Lord, let's take it a little further. Just take it a little further. When you domesticate an animal, my Lord, it's happened over the last 5,000 years. You have to subject, my Lord, the animal to what I call a carrot and a stick policy. Whether it's a dog, whether it's a horse. So you catch hold of a dog, catch hold of a horse, blood wild horse, who's, my Lord, running around in the wild, has had no interaction with humans. You catch the dog, the horse, you put him, my Lord, in an arena, he can't escape. Then you slowly try to tame him, you sit on it, it'll throw you off. You then, my Lord, whip the dog, whip the horse, you put him into submission so that he realizes that there would be a master. The master uses a carrot and stick policy. It will whip him, may not give him food for half a day, so that, my Lord, the horse becomes submissive. And when the horse does what the master wants, it gives him, my Lord, a carrot. It happens with a horse, it will happen with a camel, it will happen with a dog. Dog in your own house. If you discipline a dog and the dog is disciplined and does a good job, my Lord, you will give him a biscuit. This is the carrot and stick policy. This has been followed over the years. And each of these, my Lord, there are articles on this.
Not confined to animals.
I was going to say that. When you send, my Lord, children to school, that old saying, my Lord, spare the rod and spoil the child. I mean, that was an old saying. Today, there is no corporeal punishment in school. My Lord, in those days, when we were in school, it was there. Very much there. So this is how, my Lord, somebody is tamed. And at that point of time, when you are taming, my Lord, the person, or the animal, you are inflicting unnecessary pain on him. No doubt about it. To bring him, my Lord, into the domestic fold. And then he recognizes who the master is. My Lord, in the case of a horse, your lordships have seen, is nothing new. You put metal hooves under the horse. The horseshoe. That is not natural, my Lord, for a horse. You are putting it, my Lord, a horseshoe, or what is called a bite. Your lordship know, my Lord, what a bite is. It is put in the mouth and it goes inside. And when you pull the rein to stop the horse, the bite goes inside. It will go here. The horse will bite on it and stop. It is well known. This is called a bite. This is not, this is actually inflicting, my lord, constant pain. This is constant pain on the horse. Forever, he will live with it and die with it. It's called a bite. Just see this, my lord. Kindly, my lord, have a look at this. Your lordship will find, we can see on one side is a ring, my lord, at the edge of the mouth, and the ring is attached to a rod. That rod, my lord, will come out of the other end, and it'll have a similar ring there. And through the ring, my lord, is the rein. Your lordship will see that? Through the ring is a rein here and one rein there. So the moment you pull it, how do you tell the horse to stop, my lord? Horse can't hear, understand what you're saying. When you pull the horse, pull the rein, the horse will stop because this bite will go inside further. Yeah. So what I'm trying to say is, my lord, it's a delicate balance. It is a delicate balance which has to be, my lord, done by virtue of rules, by virtue of ensuring, my lord, that unnecessary problems do not occur. But this kind of thing, my lord, per se, is actually speaking suffering, per se. But it is justified because of domestication. How?
So instead of unnecessary, can you say that it is unavoidable?
I
Unavoidable for the purpose.
I am very grateful, my lord. Unavoidable is also a phrase. Can you remove this? Technically speaking, the horse was not meant to have this, my lord. Or if somebody sitting over it. Or a donkey, my lord, being a beast of burden. They were not supposed to be beast of burden. Just because, my lord, he's born in that fashion. And he's not like a horse. Even today in this country, my lord, in several mountainous areas or certain regions of this country, most regions, these donkeys even today carry 50 kilos, my lord, of weight. Day in and day out. Day in and day out. Elephants, my lord, in Kerala and other places, carry lumber. Are they supposed to carry lumber?
Human beings do that.
Human beings do that. You go to, my lord, mountainous areas where people can't go to religious places, they are put on the back.
Nainital, I've seen.
Nainital. First you used to have a palki, my lord.
Yes.
Palanquin. Carrying that, or somebody gonna, my lord, all this is there now. You can't, you cannot, my lord, what I'm trying to say is, you can't look at all this in isolation. As if this is the highest pedestal which is there and all the other, my lord, human and those rights, my lord, are not looked at. That not, my lord, a correct approach. Now, my lord, there was a reference in para 15 to bull tamers. Because bull tamers was used in the PCA Act of the state in 2009, my lord. So the court has an adverse view of bull tamers in para 15. Now a bull tamer or a horse tamer or trainer is very much required in our system to domesticate. Even when you use a bull for plowing, my lord, a field or as a beast of burden, will you not domesticate it? How will you domesticate it? By a tamer or a trainer, whatever you call it. Para 15, my lord, castigates the provision of bull tamers, my lord, in the PC Act of 2009, sections 4 and 5. That, my lord, with respect, is not the correct approach. So I have, my lord, finally two submissions on this. One, that this is wrong, yes, I don't say it again. Legally, my lord, it suffers from two problems. One, that these conclusions are reached without precedent, without discussion, and therefore, my lord, they are susceptible to the principle of per incurium or sub silentio. As explained, my lord, by Justice Sahai in 1991 4 SCC 139, paragraphs, my lord, 40 and 41. I don't want to read it, my lord. 40 and 41, his lordship discusses. Because the problem was, in an earlier judgment, my lord, by an abruptly, a purchase tax was replaced by sales tax. Actually, it was, my lord, just a typographical error, actually. Purchase tax was replaced by sales tax. It could have been corrected by an IA. But since it was a Supreme Court judgment, the High Court, my lord, decided something. It came back to Supreme Court. And then the Supreme Court said that it abruptly came without any assuming, my lord, it was to be brought in, not by a mistake.
Para which you're reading?
My lord, 40 and 41.
40.
41 says incuria is carelessness.
We'll go through that.
Yeah, para 40 and 41. Your lordship may see them, right?
Yeah.
It says
We'll
any
go through it.
declaration.
We'll go through it.
Right.
We have understood your point. Yes.
This is followed, my lord, by several judgments. I'll give you one more and leave it at that. Mr. Justice Chauhan.
Just hand it over.
I'm just giving this.
Followed in, you can be.
Yes, yes. All right. Now, my lord.
There's one argument of Shyam Devan, which he
Yes.
said, we just want to know what your response. He said that Article 21 through the conduit of human lives being lost. Also, because we are forgetting the other angle to the Jallikattu, which is that apart from animals being at the receiving end of cruelty, as it were, a lot of humans are losing their lives, injuries are taking place.
Lord,
What do you say about that?
Lord, with great respect, in every field of activity, people lose their lives, my lord. You are driving on a road. You may not, my lord, be driving rashly. Somebody else does something. Somebody may die. Some truck may overturn. Some building may fall. Some bridge may fall.
But you are enabling it, enabling this to take place. The state is permitting it to happen. What is more, the state is actively promoted it by putting it.
Lord, there also the state is promoting people to drive at 100 miles an hour. If you go from here to Agra, they made a road. The minister says drive at 120 an hour. It's a great road. I mean, it's a state which has done all this. So, my lord, this, and at the end of the day, my lord, it's not as if that millions of people are going to be killed like a famine. It's not one of those, my lord. I don't think, my lord, it's be stretching 21 in the same manner, my lord, that the judgment is stretched 51A into 3 and 11. I don't think, my lord, that should really.
That's it.
My lord, that Justice Chauhan's judgment which follows.
You can just give the citation.
Yeah, my lord, just citation. 2011, 7 SCC,
Yes.
639, para 65 onwards.
We'll
65.
go through it.
Yes, that's it.
Anything more?
My lord, just as an aside, Justice Chauhan used to have a diary, my lord. Always.
Black diary.
All the judgments.
Black diary, black.
Black diary. My lord, I asked his lordship once, my lord, and he showed it to me. So it contains, my lord, in his hand, all the judgments, my lord, on various.
Oh, yes.
And that's why this judgment, your lordship will find, each judgment will have 50 citations.
50 citations.
Always.
In one judgment, you get a complete digest.
Complete. But I have asked him, my lord, he still has it.
Yes.
Yes.
I said you should donate it to a library or somebody came, my lord.
Oh, it's sold. That is sold.
He doesn't want to do that.
The part of it. Yes.
My lord, the second objection of mine was
Yeah.
that what the court has done in reading 3, 11, 51A, 21, etc. amounts to legislation. And courts do not legislate. Your lordship may note, my lord,
Amounts to legislation.
yes,
Right.
that you read everything together as if one has gone and welded into the other.
Yes.
That is, my lord, 2002, 4 SCC, 578, 7 judges. 2002, 4 SCC, 578. Now, my lord, I am done with this. Only 5 more minutes I want, my lord. No more. My lord, now I've left the judgment. My lord, in the current scenario, Mr. Simple took your lordship through the rules, my lord. I don't want to, my lord, take your lordship through the rules again. But beyond the rules, we have several, my lord, SOPs, standard operating procedures. Not only the rule, because I heard your lordship say in the earlier part of the discussion that some of the rules, my lord, were not absolutely okay or tight enough. I understood that. There are some SOPs, my lord, which seek to fill up that. And my second submission there is
That SOPs for different departments. Different department, different SOP.
yes, yes, my lord. And my second submission at the last would have been that should your lordship find that there are some gaps, my lord, in the rules, I invite your lordships to indicate, my lord, in the judgment that they need to be tightened, and we'll do that. But that cannot lead to a situation of either, my lord, holding the law bad or holding the event bad.
Part of reading down.
Yes, reading down, or your lordship wants to give suggestions that please do this, this, this. I had said it, Milord, in the NJC case, that if the court did not find Milord favor with one or two clauses, the court could tell us, and we would have Milord gone back and done it. But the court didn't do that. That's all right, Milord. I mean, I'm just saying, Milord, it happened, and I think it was in this very courtroom. It was in this very courtroom, Milord, if I'm not mistaken. This one or the next one. Anyway,
Yeah.
so Milord, those SOPs, if your lordship will have, Milord, volume 3 of the joint compilation. Just very quickly, I'll show you.
So,
Milord, page 1051 onwards. I just give you a flavor, Milord. I will not read most of it.
yeah, don't read because
Yeah, I won't read. Just the flavor. In 5 minutes, Milord, just give you a
What is the page?
Milord, 1051 onwards of joint compilation, volume 3. It has been issued to all the collectors. Though, Milord, it is only South Tamil Nadu where this event is popular, only in the south. 3 districts, Milord, Dindigul, Milord, Madurai, what is it? There's one more, but difficult to pronounce. Aryan. So 3 districts, Milord, 2 I know, the third I didn't know. 1051.
yeah.
My lord sees the subject, my lord. Animal Husbandry, Jallikattu 2021, assigning duties and responsibilities to departments, SOP for Jallikattu, reference PCA, then several GOs, etc., etc. See, my lord, second para. In order to facilitate conduct of Jallikattu. Volume 3, please. My lord, kindly see 1051. Does Justice Roy have it, my lord? It says Convenience Compilation, Volume 3.
So basically, it's sort of SOP.
Any, my lord, large number of SOPs. Justice Roy doesn't have it.
It's okay. I understand that you are speaking about the SOPs issued to further safeguard the.
My lord. It's like gaps. Some of what is your lordship's comment.
Executive instruction.
Executive instructions, guidelines, whatever you may call it.
No difficulty, we'll go through it.
Yeah. So it goes on, my lord, from 1051 and goes on, my lord. I want your lordship to see, my lord, 1061. Just see 1061, one page, my lord. See, my lord, the checklist. It's a checklist, my lord, which has to be completed successfully before the government will grant you permission. Kindly turn to 1061.
Yeah.
Whether the organizers inform district collector in writing, prior permission, whether the place is notified in the gazette, whether collector granted permission, whether names of participants are registered, whether venue is inspected, whether committee is concerned of district office to oversee, conduct Jallikattu in conformity rules, whether bulls are tested by animal husbandry, whether bulls are tested by so and so disease, not intoxicated, etc. You also recall intoxication, cheating substances and all that. Whether organizer arrange Jallikattu open ground, collectors giving consent, then bull holding area, whether they provide adequate space. There was a lot of discussion before your lordship, small space, this, that, and the other. Whether bulls provide adequate feed, water, shabiana, all that. Because one phrase used in the judgment is, don't keep the bull in scorching sun. That's the phrase used. But my lord, I asked myself, suppose there was no domestication, the bull would be either scorching sun or snow. We have given, my lord, a shed to him. We give him food also. So it's not, my lord, you can't look at one side, is all I'm trying to say. You have to look at all sides. Domestication has problems, but domestication has advantages too.
See, if you are conducting this test by the veterinary doctors or animal husbandry,
yes.
Now why not such a thing be conducted immediately after the race also? So anything whether anything was done during the race, that can be detected then.
Could be.
Immediately after.
Yes.
Because
Yes,
during
we
the
are
race,
certainly open to
tail twisting,
we are
etc.
certainly open to do it. Your Lordship can record my statement. The officers are here. We
Because
will
the-
instruct them to issue an SOP right
The
now.
allegation is that during the riot is
Something, yeah,
all
yeah.
these things are being done. So once prior to that, if you are conducting this,
Yes.
nothing was there then. So immediately there are.
Milord, we will do it. Your Lordship can record. Secretary is here. We will instruct him right now. Not difficult. Goes on to some.
It's not being.
See, Milord, the checklist goes on and on.
The yard, they will collect it.
We'll do that, so that also can be.
Your Lordship could record, Milord. We will do it. I'll instruct him right now in writing and they will, Milord, put in SOP. No problem.
Anything more?
Yeah, so it goes on and on, Milord. I don't want to read it this up.
We don't have to.
Milord, I had a compilation to show how exactly it is done. An application is moved, somebody looks at it, then this checklist, all that is there, but you forget the application. Milord, there is lastly, Milord, I found one article when I was doing a research about an officer, professor of philosophy from the US. The article is, do animals have rights? I want the Lordship to see it. I did not find anything else, Milord, except this. Just have a look.
The lady.
Sorry?
It's written by a lady.
No, Milord. One Mr. Carl Cohen, Department of Philosophy, University of Michigan.
Which year is that?
Milord, this.
97.
Milord, copyright is of 97, but I think it's an old one.
We'll go through that. We'll go through that.
It's an old one, yes.
We'll go through it.
Milord, just there's some very. Kindly, Milord, turn to 94 for a second. Just see, Milord, the first para under the heading, why animals do not have rights. My lords have that. Yeah. Many obligations are owed by humans to animals. Few will deny, but it certainly does not follow from this that the animals have rights, because it is certainly not true that every obligation arises from the right of another. What I was trying to say, at least in the case of animals. 3 lines down. But the proposition all rights entail obligation does not convert simply, as the logicians say, from the true proposition all trees, plants, does not follow all plants are trees. Similarly, not all obligations entailed by right. Some obligation, like mine to repay the money I borrowed from you, do arise out of rights, but many obligations are owed to persons or beings who have no rights whatsoever in the matter. They turn to the next page, middle. Animals cannot be the bearer of rights, because the concept of rights is essentially human. It is rooted in and has force within a human moral world. Humans must deal with rats all too frequently in some parts of the world and must be moral in their dealing. But a rat can no more be said to have a right than a table can be said to have an ambition. To say of a rat that it is right to confuse categories, to apply its word to a moral category that is contained only in humans, etc. Then this goes. That's Milord my subject.
Thank you.
Milord, I just wanted to mention one thing. Yesterday, your Lordship had asked me to circulate a note on the Maharashtra Milord stand. May I just do that? And secondly, Milord, just to, in my earlier note, we have dealt very elaborately with the rules, because yesterday we could not place the Maharashtra rules. That is in my first note. So these are the 2 Maharashtra notes.
We are for Karnataka, Milord. My 5 minutes.
5 minutes.
5 minutes. 5 minutes. By 3 o'clock, we'll go back to the other side.
Yes,
Milord,
I am appealing for state of Karnataka.
Karnataka, we have not heard so
Yes.
far. Yes. Yes, tell us.
Our amendment act is also impugned in writ petition 1152 of 18.
Yes, tell us.
Lords, please take it that when your lordships decided Nagaraj, the event in Karnataka was not subject matter of Nagaraj.
Kambala is different from Jallikattu.
Kambala is different from Jallikattu. Also, bullock races in Maharashtra, as is dealt in by Nagaraj. Lordships will find that in paragraph 2, we are dealing with Maharashtra and Tamil Nadu of Nagaraj. Lords, what happened is that after the judgment in Nagaraj,
First brought an ordinance and that was replaced
the
by an
petitioner started writing representation, saying that because of Nagaraj, your race, which is called Kambala, is now become illegal, and therefore you should stop it. That's why we brought an ordinance, Milord. It was, my lord, ultimately substituted by an amendment act. It has also received presidential assent.
Okay.
In fact, this writ petition, my lord, was tagged after the referral order made in Jallikattu's case. This writ petition, my lord, was tagged.
In how many cases is the Karnataka Act actually in question?
Only one, my lord, I could find 1152 of 2018.
1152 of
2018.
only one.
Only one.
Oh, very good.
And tagging order is also subsequent to the referral order.
And I think it was Mr. Luthra who appeared for the petition.
That's correct. That's correct.
That's right. So you make your.
Yes. Now, there's 2 or 3 things I want.
Whatever it is in Maharashtra case, you are adopting.
That I am adopting. Whatever Mr. Sibal argued, whatever Mr. Rohde argued.
Adopting Maharashtra. Yes.
There are 3 or 4 things I want to indicate. One, in the counter affidavit which we have filed, we have described the nature of race which happens.
Rules are made.
Rules are made. The nature of race, my lords, is for a particular kind of, the race is through a particular kind of buffalo.
That's right.
100 to 135 meters, only found in coastal region of Karnataka, my lord. The buffaloes are also only found in coastal region of Karnataka.
Is it buffalo or
bullock? Bull. No, domestic water buffalo they are called. Domestic water buffalo they are. The race takes place in slushy water fields.
Slushy water field.
About 15 to 20 seconds, my lord.
20 seconds.
Yes, 100 meters.
It's only 100 meters.
That 135 is what the counter says.
That is stipulated in the rule.
That's not how the event is described in my counter. That's not stipulated in the rule.
So 20 seconds. Is it ticketed? Ticketed. Will they collect money to actually watch it?
No, that's the averment in the petition is, my lord, that it is not ticketed. So I don't have to, my lord, really deny that averment.
Then what else is there?
Lords, initially, my lords, the batch of business in Karnataka High Court after your lordship judgment in Nagaraj.
Yes.
High Court, my lords, directed state government to conduct an inquiry at the ground level as to how these races happen. That inquiry report is at page 324. Those were interim orders. They were, my lord, ultimately disposed of because that year passed by.
Oh.
Page 324 of volume 1 of that convenience compilation which petitioners have given is a report, is of the spot inspection report by a 3-member committee, my lord. It says that all the rules just prescribed by AWBA and the rules framed by the state government are being followed.
Yes.
There are 2 rival reports, not one by them and one by us. We don't mind if the lordship sees that any race which is available on social media. I am not saying one will be different than the other, all will be same.
Only bulls are used.
No. Only buffaloes.
Only buffaloes.
Yes.
And 2.
A pair of 2, my lord.
Only one person will ride.
They will not ride. They will run behind the buffalo.
They will not ride. Makes it worse.
They will not ride. No. They'll run behind the buffalo.
No whipping, no kind of.
No, whipping is there, my lord.
Whipping is there.
Whipping is there. The video shows that the whipping is there.
You permit?
Yes.
So will it not attract levity?
No, it will not. I'll show. So therefore, my lords, one, that site report at page 324, rule at page 328 of same volume 1 of the compilation. Lords, 2 legal propositions and 1 article in addition to what all have been argued.
That's all.
Yes. Lords, a propensity of an act being misused, since your lordships are dealing with validity.
Mr. Goel, give us the page once again.
Yes, I'm sorry, Lords. Page 324 of volume 1 of compilation is the report at the site by the committee. And page 328 of volume 1 are the rules.
This is repetition 23.
Lords, that deals with the 2016 notification of the central government under 22 of the main act.
Karnataka involved in this repetition 23.
Lords, yes, notification Lords, is common for the entire country. Lords.
That's right, but is the Karnataka state involved?
No, but our act is after that.
Is the Karnataka?
Lords, I don't know. I don't have a notice in repetition 23.
Yeah.
That in any case challenges the central government notification which was withdrawn. So, Lord, so far as those two broad grounds are concerned of legislative competence, we also say that it falls under NT 17. That's Lord's. And in so far as Lord's infraction of a constitutional provision is concerned, or any other provision of constitution is concerned, Lords, we say that there is no other provision which is violated. Number one. Number two, an allegation or an apprehension, rather, Lord, will be correct phrase, that an act or an event might be misused cannot, Lord, lead to quashing of a legislative action, Lord. Just one judgment, para 145 of Roger Matthews, your Lordships have said so, or reiterated so in 2020, volume 6, SEC, page 1.
Yeah.
The second legal proposition, Lord, over and above what has been argued, is, Lord, what would amount to remove the basis of the judgment?
Case, the state of Kerala versus Tamil Nadu.
That also, Milords, but Milords, a slightly detailed disposition is there in this Hindustan construction that arbitration came by a three-judge bench. That's 2020-17 SEC 325. Those 2-3 paragraphs, Milords, if your Lordship permit, Milords, subject to time.
Give the paragraph.
Para 53 to 58.
This is an Nariman judgment.
That's right.
We have seen.
Para 53 to 58. Lord, specific contention that the basis of the judgment you wanted to remove was not placed before the legislature is negated, my lords. And even an amendment, 2020, volume 17 Supreme Court cases.
2020, volume 20 SEC.
Volume 17 SEC. Page 325.
Paragraph
53 to 58.
We'll go through it.
Includes even an amendment act.
That's right.
Now, my lords, the third submission, my lord, is based on an article, my lords. One more article, my lords, other than over and above what Mr. Rodki gave, my lords.
Please pass it on.
That, my lords, deals with the judgment of your lordships in Kambal, in Nagaraj, specifically.
Written by?
Lord, it's actually written by two law students. It's published in SEC. In 2014.
So you can just give the citation to SEC?
Lord, the SEC has a NUJS law review citation.
We'll see. Law students. We'll write it law students article. Right.
Yes. But Lord,
to identify.
Please permit me to, Lord, just read 2 or 3 pages there.
No, don't do that. We'll go through it.
Lord,
when you say we'll go through it, we'll go through it.
Very good. Please then, my lord, sir.
Very good, thank you.
5 minutes.
So you didn't say about the whipping part. You said you will come to it.
Yes. Now, my lords, on the whipping part, my lords, what we have actually done, if the lordship goes back to 11.3, there are 5 or 6 exceptions which the legislature provides. There are, my lords, one of these exceptions is, my lords, nose roping. So the entire event, insofar as state of Karnataka is concerned.
Do you remove the ropes when they run?
I'm sorry, my lords.
Do you remove the ropes?
No. So, my lords, if nose roping, my lord, is permitted under 11.3 by the central legislature as an exception, then we have amended that 11.3, my lords, and added Kambala. So what we have effectively added, my lords, is whipping to the extent it is permissible. Now, my lords, there is no literature before my lords, no data, there is no death, there is no ticketing, as the lordship also put. It's attended by local villagers. Is the pleading in the writ petition itself.
Yeah.
So, Lord, in absence of any.
Throughout this 20 seconds, you continue to whip it?
No.
Only in the beginning?
No, there is no data. Lord, therefore, Lord, the writ petitioners have alleged that inherently writ whipping is torturous.
That's right.
And that, Lord, we have denied. Therefore, the committee was appointed. The committee was directed to be appointed by the High Court.
They got a thick skin.
No, I don't know if your lordship are referring to humans or me, but yes. But yes, the whipping is not continuous. Lords. There is no data except some photographs.
Occasional whipping.
Occasional whipping. Permissible under 11.3, competency is not under.
Why do you say it's permissible under 11?
Because we have amended 11.3 by state.
All right, all right. City Council is there. Most of you will.
Yes.
2 minutes, 2 minutes.
My lords.
Don't, we'll not allow you to take.
No, I'm not taking. I'm not going to read any books, my lords. I have a written submission. I have given.
Who are you, Jayant?
My lords, I am appearing for IA number 174687 in writ petition number 24. Please kindly pass this written submission, my lords.
What is your submission?
My lords, I am the bull owner. I have 13 native bulls in my farm, and my bulls participate in this event. I am organizer. I was a minister and sitting MLA, and my district is the highest this conducted in the Jallikattu. IA number 147. Oh, sorry, 174. I'm sorry, 174687.
174687
of 2022
in
writ petition 24 of 2016.
Yes. Anything more?
Yes, sir. My lords, I just kindly have my 5 minutes, but I'm not going to read.
Can't be.
No, my lords, there.
Just say 2 minutes and we'll finish.
Yes, 2 minutes. Kindly see, my lords, fundamentally the argument started by saying that you are not coming under the entry 17 because it's not a prevention, it was perpetuating. My straight answer is, and the argument starting with that is fundamentally wrong. My lords, prevention is not a mere prevention. Kindly take my notes, my lords, let's go through it.
We'll go through that.
4 pages, my lords, kindly take it.
We'll go through your note. When you have put it down in notes, you don't have to argue.
Your lordship have seen entry has to be given widest interpretation.
That means I'll only ask
Yes.
you.
What is the prevention, my lords? Prevention here means, my lords, categorizing animal, defining a cruelty, permissible limit of cruelty, usage of animals, regulations, prohibitions, exemptions, everything encompasses in 17. So starting with saying that you are not covered under the enforcement is wrong. Second point, my lords, your lordships are testing our state amendment, section 11. My humble submission, my lords, it can't be. Because, my lords, we are not testing a section 28 against section 11. Once the state amendment comes, it becomes a part of the central enactment. It is a central enactment. You don't test any amendment of Tamil Nadu existing provision in the central act. It can't be done, my lord, because the repugnancy test will never applicable such a situation. Once the state comes in, get a precedent assent, it become a part of the central enactment. So that point is the repugnancy testing qua 11 is gone, my lord.
Yes.
Then, my lords, Jallikattu is recognized by the state as a cultural traditional event. My lords, who can challenge this, my lords? Who can challenge? A person sitting in USA and UK having headquarters coming and telling Tamil people this is not your culture.
Correct.
My lords, your constitutional violation, you can come and challenge. But you can't come and which is my culture and the state recognized by act. My lords, in 2016, state did not recognize it as an act by act. Now by statute, it is recognized as a cultural event. Then some third person cannot come and say unless that's the third point. Fourth point, my lords, comes under the 15 and entry 15. Preservation of animals. My lords, I said in my written submission, my lords, 4 breeds were used. Out of this, 1 breed is no more even counted now. It's almost extinction. Well, these cows are giving only 2 to 3 kgs of milk when comparing to imported breed. My lords, then fourth point, Article 1420 and the last point, my lords, mere abuse or violation of law, possibility of law will not make the law. In my written submissions, that's the last point. 2005, 7 SCC, 764.
Very good. Thank you.
Well, that is the last judgment. I have given whatever the judgment, even knocking out the basis of the judgment has given.
2005, 7 SCC. Just a moment, Mr. Senior Counsel.
2005, 7 SCC, my lord.
You wanted to say 5 minutes the same way?
Well, it's my written submission. And one more thing, my lord, I have given the details of all the animals conducted, performance in the globe, pig, everything, cat. Then India. Then another, my lords, in bull, how many countries?
Very good, very good. You are doing
this compilation is given.
I am for I am for immediate response.
Please finish it. 5 minutes each.
Can be very brief. I may not exceed the time limit. Yes,
not even 5 minutes.
Yes, I am only bringing to notice.
Who are you, first of all?
I am the petitioner in IA number 11/2016.
In petition?
He is an association, registered association.
Petition.
24 of 2016.
What is your same point you are adopting? IA number 11 of 2000.
IA number 11 bar 2006.
In the petition 24 bars. Yes, what is it that you want?
That's only 2 points I want to highlight, nothing more. I do not exceed the time limit. You will not put any param. These are all point number 1.
They're all payment. Subsequently, they
But in 2009 Act,
yes,
was struck down mainly. One of the grounds was that it allows taming of bulls. Taming is contrary to the Act. Therefore, it was struck down.
Correct.
Now, you are not kindly
the basis will change. We understand.
But now
You see that
taming in
your IA is a pre-amendment IA.
No.
2016, when was the amendment made? 17 years.
After that only it was the repetition was amended.
No, then did you amend your IA also?
I only have 40 minutes.
You are basically supporting the Jallikattu.
Yes. Supporting
So
Jallikattu.
anything more you want to add, which is new?
I am concerned.
Otherwise, we have, the scarcity of time. Don't repeat. We have understood your line of argument.
Only one thing, not I am trying all the other things, I am giving my written submission.
That's all.
But only one thing I would highlight. One few lines I will read, you not kindly permit me. So all should say how the Jallikattu is being celebrated in the state of Tamil Nadu. But I am a man from Tamil Nadu, I know personally because we are organizing, we are conducting. See, I have narrated my petition itself. How it is.
Correct.
How it is done.
You treat it with the utmost affection.
It is not an event, it is not amusement, it is a festival. It commences from Pongal. It is a festival. It is not an amusement. It is not an event. It is not a sport event.
Therefore, related to culture also.
Culture. How it is arranged. You will kindly consider. Few things, I will say. No, 1 minute.
Yes.
1 minute instead of, you say, we don't.
But I have been waiting here for 3 days.
You can say that's why we are permitting.
Yes. Jallikattu festival is organized on a particular day in a village.
January.
Few days before that, the village meeting is held.
Yes.
Where it is held, it is held in the temple. In the village, a common temple it is held. There all the people converge. They decide as to how to conduct the festival. Then on the day of festival, before the bull is taken from the house, family members worship it at the home. Then only it is brought here. Number 2. Number 3, the surrounding villages gather. Common feast is arranged in the temple. I am connecting with the temple. Common feast is arranged. Contribution is made by the villagers.
Everybody except the bull enjoys it.
Bull also enjoy. How it is done.
That's fine.
Before the commencement, everyone goes to the temple. There, the temple bull is taken. It is garlanded and it is worshipped there.
All right.
It is worshipped. Thereafter,
You have understood. There is a lot
the
of.
bull is brought to this arena.
You have now exceeded your minute. Yes.
My lords.
I am submitting my
Just 2 minutes for you all.
Yes.
Time in IA number. Just a moment.
1 second.
Lady,
My written submission will be received on
We
record.
have seen this.
My lords, I appear in IA 28460 of 2022, my lords, and writ petition 23 of 2016.
Okay.
Here, my lords, I am appearing for the Bull Owners and the Bull Owner Association from Killa Raipur, Punjab. Now, my lords, why I'm saying that is, my lords, because in Jallikattu matter, in Nagraj's case, in para 74, my lords, has categorically held Jallikattu and bullock cart races to be illegal, my lords. So there was an amendment which came to
Know that. What's your point?
My point is, my lords, that bullock cart race is different from Jallikattu. It is done in a stadium. It is not done, and there is a jockey. Apart from that, there are no tickets. So it does not come within the purview of performing animals, section 2B of the Prevention of Cruelty to Animals Act. And apart from that, my lords, and also section 21 and 22 of the Prevention to Cruelty Act, my lords.
Correct.
It's not a performing animal because we do not sell tickets, we do not sell, and it is known as the Rural Olympics of Killa Raipur, and it has been doing from 1933.
This is which state we are talking about?
Punjab.
This is from Punjab.
Yes. I'm appearing for the Bull Owners, my lord, and the Bull Owner Association.
We are not really concerned with that.
No, I'm not a writ petitioner. I have filed an impleading application in writ petition, my lords, because the notification specifically states that states of Karnataka, Tamil Nadu, Karnataka, Maharashtra,
So this relates to Punjab.
Punjab,
Okay.
and it is known as Rural Olympics. It is, and bullock cart
race is one of the races. There is dog race, camel race, horse race, and then athletics for
Only a bull race actually.
cart race.
Bull cart. Okay.
Apart from that, no, 2 minutes.
That's
2
enough.
minutes, my lords.
Sorry.
My lords, 2 minutes. Here we find my lords. Lordship
We'll not
article,
comment.
article 29, my lords.
We will not
In
comment you.
TMA 5,
We have
11
understood-
judges
we have understood
speaks
you
about
are giving
29.
Part of the session.
Can I then
That's
give
it.
submissions?
You can give your submission.
Lord, I am appearing in IA number 67113.
Yes.
Lord, I am owner of, Lord, I am having a foundation, cattle preservation
All
foundation.
right.
Lord, my
Tamil Nadu.
submission is this.
Tamil Nadu.
Of Tamil Nadu.
Then.
My submission.
Lord,
Anything new?
yes, Lord.
Just whatever is new alone.
Only two
Just
sentences.
make sufficient.
Lord, only two sentences.
Yes.
Lord, Jallikattu, Lord, is neither for an entertainment nor an essential human activity. It is an essential activity to preserve the breed.
It's been argued.
Lord, that's why. Lord, I have filed my written argument. Lord, your Lordship, please to note, page 10.
Lord, I have got a totally new
Lord, one more submission, my Lord.
New
Lord, your
grounds.
Lordship, also please to consider, Lord, the Convention on Biological Diversity Act. Lord, in which, Lord, it says.
What is your IA number? What is your IA number?
67113 of 67113
of
2017.
In which repetition?
24 of 2016.
Okay.
Lord, I have filed, Lord, the convention, a spiral binding. A small recommendation, biological
My lords, please note the citation, my lords. It's a 11-judge bench.
I only want, my lord,
2002
of time, your lordship will find the judgment at page 77 entry.
You're who?
Well, as I am, the learned SG was reading, I was also appearing for union in some of the.
Okay, you are for the union.
77 is an interesting judgment, my lord. Your lordship will find it interesting.
Lord,
I
I
am
also
appearing, I am appearing in IA number 14, Lord, in repetition 24 of 2016. I am for a bull owner. My point is very simple, Lord. In so Nagara judgment is considered per incurium. In so far, in as much as it is not considered.
IA
number 14, 1-4.
In what?
In repetition 24.
14 of which year?
2016.
And in which repetition?
Repetition 24. Yes, Lord. I am for the bull owner. My argument is, Lord,
You're Andhra, I mean,
Tamil Nadu, Jallikattu, representing a bull owner. My argument is, Lord, Nagara judgment is, Lord, per se is incurium. In as such, Lord, it has not read, Lord, Article 32, Lord, in its true letter and spirit. Why? Because it has read Article 51A. It's over as it connects to part 4 of A of the Constitution, whereas 32, Lord, only confines, Lord, to part 3.
Fundamental rights.
Fundamental rights, initiative of Article part 3. So part 4A.
Correct.
Secondly, Mullah, it's over to Justice Mullah, the Aniruddha Bose at the post of query to us saying, in Income Tax Act, how it is considered. Mullah, it is considered as a personal effect. Being a movable property, Mullah, section 241, Mullah, 214.
All right, that's
it. Yes.
I am also filed, Lord, circulated. Yale Law Journal.
Say,
IA, my lord, 167905 of 2022.
you are from which place?
Submissions. I am one of the in repetition.
IA number? IA number?
167905 of 2022. I am the member of the parliament from Madurai.
In which case?
In 24, WPC 24 of 20.
No, are these IAs actually allowed already?
Well, that has been. Yes.
My IA was allowed below IA number 2.
So, Magar, what is it that you are MP?
Yes.
What do you want?
My lord, I support Jallikattu. One thing I thought I should submit. Yes, my lord,
Your IA is
judgment
of
the New
which
York
year?
Supreme Court
Your IA is of which year?
of the year 2022. Now, one submission, my lord, I will not take much time. My lord was asking, day one, my lord was asking on the rights and duties and the Salmon's jurisprudence. Now, there is one judgment of the New York Supreme Court where, my lord, a chimpanzee was sought to be given a writ of habeas corpus. The rights and duties. I didn't see that because she didn't. She was relying on the other judgment wherein the dolphins was sought to be. The question is this, my lord, rights, my lord, are available to the human beings. One aspect, my lord, was also asking on the Environment Protection Act. Now, there can be two ways of looking at it. Nagaraja has gone on the pretext that it is the rights perspective. It ought to have been on the duty perspective. Now, if it is the duty perspective, my lord, the utility value for the persons are available.
Correct.
And therefore you will
So,
net
Madam,
21.
Madam, give us a
Yes,
judgment.
I have made a.
I appear not for the.
There are totally new points I want to place. Lordship, kindly accommodate my request.
I appear not for the former Chief Minister of Tamil Nadu, who was the Chief Minister at the time of the passing of the enactment. I support Jallikattu. My IA number is 180000 of 2022.
1800?
4 zeros, my lord, of 2022, writ petition civil number 23 of 2016, my lord. Now, this is Thiru O. Pannirselvam, who was the Chief Minister at that point of time.
That's right.
Lord, I am just handing over my written submissions. If your lordships permit me 30 seconds.
30 seconds allowed.
Yes, my lord. Lord, the new thing that I will be talking about, my lord, is that there is a New Zealand enactment, my lord. Now, the reason why this enactment is special, my lord, is that it specifically confers personhood on a river named the Wangui River, recognizing the Aboriginal claim of the people there. Now, my lord, the reason why I cite this statute is that it spans to approximately 126 sections, stating in precise detail as to what the effect of conferment of personality entails. You know, my submission is this, that 14 and 21 of the Constitution specifically refer to person. Person is, my lord, defined in the General Clauses Act, Article 367, my lord. Includes. Yes, yeah, that's right, my lord. Now, my lord, the Indian statutes, my lord, that define, that create legal personality, for example, the Companies Act or the LLP Act, they flesh out again in great detail every single facet of this personality. Now, my lord, if that is the case, then, and you know, other jurisdictions are doing something similar. My submission is that the conferring of personality is necessarily a legislative act. It is not subject to a judicially manageable standard, and therefore, my lord, it is only the legislature that can do it. You have 15 more seconds, my lord. A second submission, my lord.
It is something new.
Yes, my lord. My lord. This just points out, my lord, the difference between section 11, subclause 3, subclause C, which, my lord, is the permission to kill animals for dietary purposes, and section 28 of the PCA Act, my lord. Section 11, my lord, allows the killing for dietary purposes, my lord, subject to the condition that it will not cause cruel treatment. But 28 is a religious exception, which is a carte blanche exception to the entire act. And my lord, and because this is a point that Mr. Divan sought to differentiate, my lord, he said that the taking of life is different from the treatment until you take life.
During life.
That's right. But if your lordship sees 28 of the PCA Act, my lord, it says that there is a carte blanche exception on religious grounds in the manner in which life is taken. So the act as originally enacted, my lord, envisages a religious grounds exception in the manner of taking life. Therefore, my lord,
thank you.
May it please, Lordship, I am appearing, my lord, in support of Jallikattu, and my IA number 2 of 2016 was allowed, my lord, on 13 January.
All right. What's your point?
My point is this, my lord, the fresh new point.
Yes.
This judgment of 2014 needs an overruling because the very basic concept, the subject matter was not understood properly by the court.
All right.
The court was mentioning about bulla when we were dealing with the bulls and calling bull as a draught animal under the 1965 rule, which I have attached, my lord, in this my copy. Lordship, kindly have a look.
You have given a written.
Yes, I have passed on a written submission.
We'll go through that. We'll go through that.
Only bullock is a draught animal. Only it is used for ploughing and other agricultural purposes, transportation, not bull. Bull is uncastrated. It is used only as a stud animal, not a draught animal. So there is a foundational flaw, my lord, in that judgment. Number 2, the judgment mentioned bull fight. There is no fight happening. I have placed the dictionary meaning here. Fight means there should be some violence involved, and that is missing here. There is no fight.
You want violence to be added.
Let me
Yes.
read
So
the
bullet
dictionary meaning, my lord. It says
right.
to attack or engage an enemy in a combat, to take part in a conduct, fight against something or someone.
All right, Mr. Counsel.
Lord,
Given your written submission, that's enough. Yeah.
So I have referred to paragraph numbers also.
We will go through that.
Number 3, legislative competence. Legislative competence is not just under Schedule 7 rule, list 2 and 3. It is also derived under Article 243G, dealing with the panchayat, read with Schedule 11, where the power is given to the state to enact a law on
this one, confer the power on the
That's a
panchayat
new point. We'll take.
in the rural setting, the villages, relating to 4 items, Milord, I am reading: agriculture, animal husbandry and dairying, cultural activities, maintenance of community asset. My submission is, Milord, this is a cultural activity, this is a community asset because it is depleting. It has to be preserved. The community has got an interest in preservation of bull.
Very good. Thank
Foreign jurisdiction.
That's a
New point, Milord, not touched by the other side.
because we said that new point. You
There's a New Zealand High Court judgment of 2022, given the citation.
Very good. Very good.
And where it was related to rodeo, they say that the approach, they've got a similar legislation. They say that ours is a animal welfare approach, not animal right approach. Lordship was inquiring during the trial whether right has to be conferred. They say similar provision.
That's enough.
Spain, let me, 2 minutes, Milord, Lordship.
No, it's not possible.
Some important point.
You have your written submission. That's why we are saying no.
Scientific advantage, A2 milk. A2 milk, Milord, it is derived. Lordship, kindly allow me 2 minutes, Milord.
We have heard you. We have
No,
given
that's
you
A2 milk.
and you have given your written
A2 milk is derived only from cows from this breed.
That's right.
Not A1 Milord is cancerous, cancer
Very good.
producing,
Very good.
diabetes producing, whereas A2 milk, if it has to be done, it is through milk.
Lordship,
Thank you.
Last one, Milord, last one. Reconciling constitutional provision, they have referred to 51A.
All right.
They refer to this one, G and H, Milord. Lordships may kindly refer to F and J also.
Very good.
To value and preserve the rich heritage of composite culture. To value and preserve the to strive towards excellence in all spheres of individual and collective activity. It has to be reconciled, read along with this compassion and.
Lordship, I am appearing in read petition 1188 of 2017, which is referred in this batch of matter. I am appearing for the farmers in Maharashtra. My point is that there are 5 in
race only in your Maharashtra is race.
Race bullock cart races. There are the farmers' right to livelihood and occupation is involved in this case.
That's right.
Animal husbandry is part and parcel of agriculture. All state acts defines agriculture.
Yes.
Animal Lordship, if these races, a sizable population in the dry region in Maharashtra solely dependent on the procreation of these bulls, which are used, and mainly the khilad bulls.
Right to livelihood. Yes.
Right to livelihood, and population of khilad bull in the year 2012 was 20 lakhs. Which was in the 2019 census reduced to 13 lakhs because of ban on the bullock cart races. About the rights and duties, I will just say, Salman says right is an interest which is recognized and protected by the rules of justice. Salman also says there is correlation between rights and duties. There is another view of Austin which says every right may not confer duty and every duty may not confer the right. That's another view.
Right.
I will just give.
I am in I number 173749 of 2019, your lordships, in writ petition number 1152. Karnataka matter, your lordship.
You're saying what?
I'm basically in support of what the stand of the state council, except for this one judgment, let's say by the constitutional court in Spain, your lordships, which say there is a ban that was imposed. Subsequently, the constitutional court has set it aside. I'll place that in my written submission.
Thank you. Yes. Now
I have filed one IA on behalf of Race Association. I will file my detailed certain submissions. And I am supporting the bullock cart in the state of Maharashtra.
Very good. Support.
Yes. Now I'll deal, as your lordship knows, I'm appearing in the one which is against the state of Tamil Nadu. I'm going to first deal with the points which were raised by Mr. Sibal, and then I'll try and I'll progress downwards. Now, to save time, for the purposes of the rejoinder, have you given it to them? I have just summarized some of the points which we want to make, and I'll take you through this so that we can proceed rapidly.
Yes. Go ahead.
I'm going to go slowly. So please allow me to hasten. Allow me to hasten slowly. This is a rejoinder. It's a very important part.
We will not assemble again for this. I mean, we have
in a constitution bench. Well, I understand the constraints of your lordships. I have
You
spoken.
you can put it down in written submission, whatever you want to say.
Brothers are rejoined, and if brothers, there has been, I don't want to tarry on this.
Let him submit. I'm not saying.
It's brothers, I'm urging the court, because this is not just a question of this one case. When the Constitution bench assembles, of course, we have to all assist the court in reaching a resolution.
Go ahead, please don't. Please go ahead.
Yes, so I will. Now, my lords, the first set, because I want to take you through this, we prepared this only keeping in mind that it is going to be it's going to save some time.
Yes.
Now, let me just indicate, we have table A, which begins at page 1. Now, the points of Mr. Sibal, which I am meeting, are these. Point, file a suit. Number 2, there are disputed questions of fact. Number 3, that there is no Article 21 issue arising in this case at all, because it doesn't have to do with the right to life as far as human beings are concerned.
Yes.
Now, let me summarize my points and then I'll deal with the aspects of the table. First point, since 2017 is the writ petition.
Yes.
And in subsequent years, there are detailed IAs which have been prepared and which are filed on the record of this court. Those IAs bring on us being supported by affidavit, bring before this court detailed reports which are based essentially on 2 sources. The first source is an eyewitness investigation of people who attended the event. They took photographs, they made their notes, and they compiled it in a report. So it's based on eyewitness investigations. The second element of the report is based on very reliable media reports. So let me explain that. You have situations where deaths have taken place and injuries have taken place across several districts in the state. If deaths and injuries have taken place in several districts across the state, what we have done is we have compiled on the basis of media reports from various reliable sources and put them first in the report. And we want to point out 2-3 factors. First factor, this is filed in 2017, 2018, 2019, 2020. The state government doesn't file a response challenging the 17 facts, the 18 facts, the 19 facts, the 20 facts, the 21 facts, and the 22 facts are filed not on affidavit, but in some sort of a tabulated statement. So they had the time to contradict. They didn't say anything on affidavit because they had nothing useful to say. And the reason why we are fortified in our submission in this regard is that if those media reports are coming year upon year, reporting death, cruelty, and atrocities, surely the state government, responsible as it is, would have contradicted the reports and said, sorry, this is completely wrong. This is false. You're spreading wrong and incorrect news. None of that. So these are not just some paper news reports on the which we have bundled together and brought before the court and said that, all right, believe what is stated here. No, they are compiled methodically. They are placed in a report. The report is placed on affidavit in this court. Now let us just please go to page 1 and I'll try and proceed rapidly. So I'll explain how this is done in the context of a couple of...
You have given detailed...
No, but I want to take your lordships through this and the report. So please bear with me. So I want to explain first how this works. I want to explain how this works because a bold statement is made that there is no facts on record and there is no facts at all about any of this. Yes.
Just other issues are there.
No, please, I don't want to. Yeah.
It's all right, you go ahead.
I'm grateful. So may I take your lordship to page 1, please, of what I have just tendered? Let me just explain this in some detail, how it works, and then it will become easier.
Yes.
So you will see column number 2. It is annexure P19 in volume 1 of the writ petition filed on 6th July 2017. More than adequate time. Now, the dates and the investigation, this is 2017 report. I didn't read this in the opening because I read it. I pointed out the 2022. So this only covered reports between 5th and 12th of February 2017. The act had come into force by now, and you will go on the next date. There are dates essentially in the month of February. Now, please see relevant pages of the report. Now, please see the bold portion. Casualties and injuries between January and June 2017. Human deaths, 15. Human injuries, approximately 2,000. Animal deaths, 5 bulls, and animal injuries, 7. Now, please go to the next column. Whether PETA reports are based on eyewitness investigations and other sources. Yes, eyewitness investigations. The photographs at the events were taken by PETA investigators. The reports from following reputed media sources were used to collate information about injuries to humans and bulls. The Business Standard, Hindu, Times of India, Hindustan Times, Indian Express, New Indian Express, and Deccan Chronicle. Now please go to the last column. State reply contesting the report. None. The state has not contested any of the media reports cited insofar as PETA is aware. Now please go over the leaf, page 3. This is the 2019 IA. Casualties and injuries between January 18 to February 18. 10 human deaths. 757 human injuries. Animal deaths, 5 bulls. Detailed particulars which are given. Please go to page number 4. IA 7th August 2019 with an affidavit in support. Casualties and injuries in 2019, human deaths 8, human injuries 597, animal deaths 5 bulls and 1 cow. Very many details further given. Now please go serial number 4 at page 5. Human deaths 13 in the year 2020, human injuries 570, animal deaths 6 bulls, and we go into the various deep. Now 2021 was a really unfortunate year. Human deaths 14, human injuries 1,119, animal deaths 1, animal injuries 8. And insofar as the year 2022 is concerned, again the human deaths soared to 17, human injuries 1655, animal deaths 2. Now please, in this document itself, in this, again drawn from this report, I would like your lordships to go, because I'm just explaining how we've compiled it. Go to page 23, just for a moment. So page 23, second bottom half, you will find a Times of India report of 2019. Bull barges into Jallikattu spectator gallery and gores man to death. So when we get a report like this from the Times of India, there's no denial by the state government. This counts as 1 death. Please go to the next page, page 24. Times of India, Kalakutti Jallikattu, bull tamer gored to death. Please go thereafter, if your lordships would, directly. Please go to page 31. Youth Hindu, the youth gored by bull during Alanga Nallur Jallikattu dies. And the earlier page, page 30. Page 29. Bull released during Jallikattu dies after being hit by train. This is from a Times Now report. And, Mirror Now report. And please see page 29 if your lordships would. 2 tamers, including a student, killed in Jallikattu event. This is drawn from the Hindu, page 29. So this is the reliability. And I think since we are not going to have the advantage of visiting one of these, look at page 34. Because a lot was said about one person mounting the bull. Please just have a look at page 34, which gives you a report from India Today and Hindu as to how this event is being conducted. There are hordes of people. lots of individuals at the same time, and the rest of it, your lordships will see, for example, page 36 from the Deccan Herald. Rights activist raises red flag after 7 die in Tamil Nadu Jallikattu. And please go again, if your lordships would, to page 35. Spectator strays outside the seating area in Trichy, gored to death by the bull. Now, with this background, I'm only going to refer to one IA. Please just take up IA. I've asked the court master to keep it ready. 55826 of 2020. 558. So this I hadn't placed earlier because they said they didn't have time for 2022. So please see the 2020 IA 55826 of 2020. Haven't we asked them to keep it ready? We had asked them specifically to keep this one IA ready to save time. Now this is being projected. What your lordships were told is that we now have a very sanitized and improved version of events. So 2017 came and went, 2018 came and went, 2019 came and went. Now we are in 2020, the fourth year in which this event is being conducted. And let us see what the eyewitness report showed with regard to the conduct of this event.
Yes.
Your lordships have it. Please go to page 13 of the report.
Yes.
This is the PETA report for investigations held over 5 or 6 days, 15th till 19th January 2020. Please go to page 13. We have a few eyewitness volunteers who have gone and tracked it and taken photographs. Now, what did they see at a handful of events? Because this is going on right from January all the way into May or June. Now, please see page 13. The impression which was given, your lordships have page 13. So the impression given was there's one bull and one human being. Look at the bottom of page 13, both the photographs. Please go to page 14.
They have said that it will be more than one participant.
No, many tamers pounce on the bull. I am pointing out the extreme cruelty. Please go to the bottom of page 14. A bull falls onto a tamer inside the arena.
Let us get one thing straight.
Yes.
You're saying all this. You're challenging an act, the rules, etc.
Yeah. Yes.
Now the possibility of it falling into disuse, abuse, or it being abused.
Yeah.
Cannot be the standard by which you will get the validity of the act.
No, I'm making it very simple. The argument was regime change. I remember hearing that expression.
Absolutely.
I am pointing out that as between, how did this court decide the case and correctly decide the case in Nagaraj? On the basis of reports filed by the Animal Welfare Board and certain supplementary affidavits.
So that
I'm sorry.
Just a moment.
Yeah.
Factual matrix
Then
no longer exists because.
So I am showing you it survives.
That's what they're saying. There might be instances where the illegality committed. Then 11 will kick in.
11?
11, 1A, etc., etc. What is it that you can ultimately do?
No.
You will punish the person who commits.
You can't punish the person. There's no penalty. Please, I'm going to show you there's no penalty provided in the rules.
That you may how we are going to.
No. I am.
In case we allow it.
Yes, of course, because your lordships are open till the end.
We are not saying that.
Of course.
We are saying
yes.
In case we uphold it, there will be a lot of safeguards which we'll have.
No, there's no question of safeguard. This is per se because what I'm showing your lordship is what the state is projecting according to us is humbug. That to show that I'm pointing out page 15. Now please go to page 15. How can you argue with this material on the record? You don't contradict it. You don't file an affidavit, and then when this is being pointed out, you say no. Please issue curative directions. This is practiced in 2020. You had the time in 17, 18, 19. If you failed to correct it until 2020, obviously the rules are not working at all. So this is an eyewash. And my lords, ultimately my submission is going to be, your lordships with your vast experience are not going to be gullible as the state of Tamil Nadu may wish you to be. You're going to examine the material on the record. So please see page 14. Look at 14. Many tamers pounce on the bull. The bull falls onto the tamer inside the arena. Now look at 15. The panicked bull charges back into the Wadi Vasal from the arena. Look at page 15. Some stray incident.
We are just saying that the bull is slightly better compared to our condition.
That may be. Let's please see page 15. Please have a look at page 15. The photograph where the bull charges back, because I mean, the whole idea of cruelty was that the sensational, not just deprivation, but the noise, the physical is so great that the flight, and he has, there is a flight response here. Now, please go directly, if your lordships would, to the, for example, go to page 44 and 45. Just look at 44 and 45, and then I'm going to show you, I'm going to read from what they have said, the sanitized version of how it is conducted. Go to page 44, please. Your lordships have 44?
Yes.
So this is the manner in which the crowding takes place. Look at the number of people on page 44. Many tamers attempt to subdue a bull and some hold by the horns. Now look at the next page. Several tamers simultaneously. 2 tamers pounce on the bull. And your lordships were told it is 1 at a time. There are 3 jumps. There's 1 hump. This hump and jump theory, which is being pushed forward by the state, according to me, is eyewash. And it is eyewash in the sense it's contrary to the record. I can understand if they said that, look, this doesn't seem to be an event. We've checked up and there was no such event which took place on this day. Or that this seems to be a photograph of another day or another year. Or this is pre-2017. None of that. This is 2020. Now, please have a look at page 59. Look at the cruelty. Look at page 59, the photographs. Is this to be ignored? Is the 59 as well as 60 of this report? So, if your lordships are pleased to turn to that. So, this is showing, what does this show?
Who took
this? I'm sorry.
Who took this photograph?
I said so. The photographs are taken by it's mentioned in the report itself. There are field investigators who went there, and on the basis of which they have prepared this report. So we have called. I have described this. Sorry.
Did he lodge a complaint with the authority?
We did. We initially did. There were some FIRs, but I am going to show your lordship. I am going to show your lordships that, and we are making these reports. You see.
Mr. Diwan.
So please just go to the, yes, sorry.
Small request. Can we draw any adverse impression?
Can you put the mic?
Mic is on.
Yeah.
Can we draw any impression based on these photographs which you have shown to us? One thing.
Yeah.
Second is, there may be stray instances in any year, but we are testing on the angle of the Constitution about the scheme in place as to whether after the assent has been granted by the President to the statutory enactment applicable in the state in question, how far it is a valid enactment or not. If you go on taking an impression based on photographs, it will be a very dangerous situation for us. We can't hold that the provision enacted in this of the Act of 1960 by a state amendment with the assent of the President is bad in law because the photographs say so. Can we say? Or can we record any finding based on these photographs that the legislation is bad?
All right, let me answer. Let me answer this question. Let's answer this question threadbare.
Mr. Diwan, would it be possible to conclude if we take it tomorrow at 2 o'clock?
I think so.
By what time? By what time?
We conclude by 4 o'clock. I think all of us will conclude. I've got 15 minutes left, and the rest of us will conclude in the 2-hour sessions which remains, the final session.
I don't think there'll be.
Yeah. We'll be very grateful. Yes.
Are your lordships proposing to sit tomorrow? You can.
What we have no option.
No. What I'm saying, my respectful request is to limit us on a particular time. We have no problem. They've had a lot of time. But, let me be honest with you. No. I have no problem.
More time now.
No. We have no problem, my lord. What we're saying is limit us to time. We'll finish it tomorrow. There's no question. Once your lordship says 20 minutes, half an hour, we'll finish.
2 p.m. with that afternoon session, we will complete it at our end. citations given to me.
Mr. Diwan, then continue on so that we continue tomorrow.
Yes, so yeah, I'll use my 15
minutes.
minutes.
Yes, can you utilize?
Yes, so now first let me use the 15 minutes to answer the question. Sorry. Your Lordship recalls. Now I'll sorry.
No, it's okay. I mean,
Yeah, I'll.
Well,
Oh, sorry. Then we'll see tomorrow. I'm so sorry.
you didn't hear.
No, I didn't realize that. My apologies. No. I'm sorry. I didn't realize that.
Because Diwan,
No, of course, Manoj.
the mic was in full swing, so nobody
Yes, absolutely, Manoj. Yes.
You can just, we'll just tell you something. There is an article in the
Bull area.
Yale Law Journal.
Yes, Manoj. I have
That is C.K. Ellen.
Yes,
There's an article, I don't know whether you're
yes, Manoj. I've also marked the pages.
That
We have circulated that article by.
Yes.
Lordship, there are two more items. 2 and 503.
Not possible today.
No. Any other place?
After vacation.
You put it after vacation, there is no point in keeping it.
I think the other matters.
Yes.
Wait for.
Obliged, my lord.